Appellate side mentioning.
Original side mentioning will be taken up now. When I take up we take up the appellate side matters, we'll take up the appellate side. Yes, please call on the list. One who is appearing, original side.
Appellate side never thought appellate side mentioning.
For the appellant, plenty family. Right.
But I appear for the respond numbers 121 to 125.
Yes.
Let us start. You have to start sometime.
For the respondent number 1, Lordship.
Yes,
My lord, I shall give you lordships, my lord, the background, my lord, but I
Lordship.
think, my lord, in fact, we were trying to, my lord, figure it out, my lord. So far as our brief is concerned, my lord, there is a supplementary affidavit, right,
Lordship, I have
which
one
brings on
indulgence.
record, my lord, the proceedings, subsequent proceedings of this honorable court. I'll tell your lordships very briefly. My lord, if your lordship looks into the cause title, my lord, the plaintiff numbered 1 and the defendants number, my lord, 2 and 3 are brothers. The suit is a, my lord, suit for partition. My lord, if I remember it correctly, my lord, 4 to 20 are, my lord, family members. Then 21 to 100, my lord, were, my lord, family companies through which the family, my lord, used to, my lord, hold properties and assets.
Yes.
Then, my lord, 121 to 126, my lord, are, my lord, the companies set up by the defendant number 1 to siphon off the assets. The suit was a suit for partition. Initially, there was an order of injunction so far as, my lord, some of the defendants are concerned, excepting 79, who was then in BIFR. Thereafter, my lord, it came to the notice of this, of my client, my lord, that the 79 was trying to, my lord, transfer property. Sorry, Sika. Yes, Sika was repealed and, my lord, thereafter they were seeking to transfer the property.
Yes.
So an injunction application was made, or addition of party along with a prayer for injunction was made.
Addition of whom?
Addition of, my lord, defendant number 121 to 126.
All right. They are the transferees.
Yes.
So it has already been transferred.
It was, my lord, so far as 126 was concerned, and 121 to 125, certain shares, etc., were, my lord, done.
All right.
Now, the learned judge, my lord, was pleased to add, my lord, them as parties, but was pleased not to grant any order of injunction. That is why the appeal.
The temporary injunction application has been dismissed.
No. It's pending. It is pending. Ideally speaking, my lord, 2017 interim order is there in the appeal. So it should really
Continue it for some time and
yes, it should go back.
trial. That's true.
But I have brought my
17 to 2025. We are into.
yes.
No use 8 years you are suffering that injunction. What harm will befall you? It is decided quickly.
But there was no order of injunction against me. I am though subsequently.
Whatever is there, we'll continue that till for a limited period and we'll request the learned trial judge.
At the time of hearing the additional order of injunction issue, but what fell from the learned judge was those defendants who filed applications for dismissal of the suit or for rejection of claim, the ad interim order will not operate on them, but it will only operate on them, on those defendants who did not challenge the maintainability of the
What
suit.
happened to that order 7 rule 11?
So some of them are pending.
Some have been
Some
dismissed.
Some of them are pending and the order of
What
injunction.
about the others?
uh,
Not sure.
they're not sure.
Must not have been allowed, either dismissed or pending.
Dismissed.
If it is allowed, then we would
Yeah.
have no occasion to
Yes.
get the pleasure of your arguments. So let us do that. Unnecessarily keeping it pending, hearing for days, prejudicing the learned single judge who will be taking up the injunction application. We do that right.
May 2017 was the order.
Order was passed on 30th May 2017.
In this appeal.
Lordship, I need 2 weeks time, Lordship. I'm for the respondent number 1, Lordship.
You will get more than 2 weeks before the learned single judge.
Grateful, Lordship.
Before the learned single judge, we'll dispose of the appeal and continue the.
Oh, Lordship, actually, Lordship, the new.
Who is keeping these matters pending?
Lordship, whatever the new advocate record was changed, Lordship. I am the new
You'll get
advocate.
time, more than 2 weeks. Grateful. At the outset, learned senior counsel for the appellant apprises the court that the present appeal is pending since the year 2017 and an interim order of injunction was passed in connection therewith on May 30, 2017. Full stop, we find that the present challenge has been preferred against an ad interim order of injunction. Full stop, since the main temporary injunction application is still pending before the learned single judge taking up the suit, comma, we are of the opinion that since the ad interim injunction passed in connection with the appeal is already subsisting for a period of 8 years, comma, no serious harm would befall the respondents if the same is continued for some further period and the matter is left to be adjudicated finally by the learned single judge
Signed.
taking up the temporary injunction
Yes,
application
signed.
itself. Have you filed your written objections to the temporary injunction? We'll grant you some
No,
time.
no.
No. We'll grant you some time for that, all the rest.
My lord, sorry to
Yes,
interrupt.
no.
Possibly some more time is required because, my lord, the application, my lord, has been assigned before, my lord, Justice Chakraborty. It has not yet been, my lord, released by his lordship.
Division
He is
bench,
in division bench. Justice Topobroto Chakraborty.
we'll request.
So, my lord, we have to, maybe, my lord, some more time.
No, we'll extend it for some time. I mean,
Yes.
we'll extend it for 2 months. In fact. 2 months should suffice.
Yes, yes.
So next para. Accordingly, comma, APO number 285 of 2017 is disposed of by extending the ad interim order granted in connection therewith for a period of 2 months from date and or until further orders are passed by the learned single judge taking up the temporary injunction application, comma, whichever is earlier. First up, it is made clear that this court has not entered into the merits of the appeal and it would be left open to the parties to take all points taken by them before the learned single judge taking up the injunction application and the suit. Full stop. We further clarify that that it will be open to the learned single judge taking up the temporary injunction application to vary and stroke or modify and or vacate the interim order and টা দেবেন না and এর জায়গায় কমা করে দিন এবার and or vacate the interim order and stroke or extend the same comma if the ends of justice so require comma subject to the full stop. Next para. There is a can pending also must be. GA rather.
Yes, my lord, it is GA.
GA1. GA1 of 2017 within bracket old number GA1613 of 2017 is also disposed of accordingly. No orders to cost. Thanks. Much ado about nothing.
Item 2 is perhaps. Item 2 is perhaps. Second to the
Sardata same. Bakita jai.
2 is my appeal, my lord. I have taken a change from my erstwhile advocate on record.
Here also interim order you are enjoying and
Same.
No, my lord, I
impugned
need to
order.
see what is the impugned
Yes,
order. I'm
is
not
that-
aware of that. I'll be very honest.
Same impugned order.
No, I'm not. I was instructed not to appear after 2017, 2018. My lord, it is after a period of 8 years that I have been instructed to appear.
we'll keep it week after next.
Yes, lordship will kindly do that, my lord.
On the prayer of the appellants, comma, the matter is adjourned till June 27, 2025.
Great.
So let us come back.
আরেকটা appeal আছে সেটাও বলে দাও।
Oh, well, sorry. Wednesday, not June 25. Yes. Till June 25, 2025.
Identical appeal আরেকটা আছে।
My lord, there is another appeal on the same point.
That's a sufficient threat for us.
No.
Copy paste appeal.
It's, my lord, the other,
But assigned to us.
the-
That is the difficulty, Mr. Explorer. That is the difficulty.
They were released together.
Either you get
they
it
were
assigned to
released
us,
together, but yes, we shall text.
either you take steps before that date. Yes. So it has to be mentioned next Wednesday and we'll keep it on 25th then.
This appeal is from the portion of the order by which they were implemented as parties. Maintainability of the appeal is.
I have to see. my lord.
Great. Let's come. Yes.
Item number 3, Your Lordship, I'm appearing for the appellants. I have just been recently engaged in the matter. The
I
instructor,
have taken the brief. don't take matters in the brief which are appearing in the before a court, and you come up and say this is very embarrassing for the court and the advocate also. Please don't do
Actually,
this.
my lord, the instructing client's wife has
You'll
just
ignore your
passed
appearance.
away.
Sorry, ma'am. No, you cannot say before the court this is not done, not acceptable by the court.
I'm
You
just
come up and say I've been briefed. Why did you take corridor briefs? You shouldn't have taken the brief if a matter is appearing. If I take a brief, I have to take responsibility the moment the matter is called up. Sorry, we have taken corridor briefs, but we made ourselves ready before the matter is taken up. Sorry.
Your lordship,
We'll
just
dismiss it
that
for
the
default.
instructing client's wife has been recently passed away.
Yeah, that does not prevent you from moving the
Can
matter.
you
You have taken the
just 2 weeks time?
no,
So
no way.
I
No
have
way.
to file my wakalatnama as well. Kindly permit us 2
Dismiss it
weeks
for
time.
default. Come back with a restoration application with your vakalatna.
Your lordship, I humbly pray before your lordship. Kindly
This
permit
bench
us 2
sits
weeks
only for
time.
these matters, ma'am. It's very unfortunate that you're asking for time whenever it is taken up. This bench is unnecessarily taking up taking up these matters only. Otherwise, you could have taken up other matters for people who are more interested in matters. Why ask for an adjournment on the ground that you have been recently briefed? Why did you take the brief?
There
Shouldn't
has
have
been a
taken the brief.
bereavement in his family. So, your lordship, kindly permit us 2
Family
weeks.
became sick since when?
His wife.
This is an appeal of 2018. From 2018, the family is sick. The entire family.
Your lordship, I was not engaged at that time.
That is not your fault, your client's fault. Why shouldn't it be dismissed for default?
Your lordship, kindly permit us 2 weeks time. 2 weeks time, your lordship. I'll take
The matter is called on for hearing, and adjournment for a fortnight is sought on behalf of the appellants, full stop. As a last chance to the appellants to argue the matter, the same is adjourned till June 25, 2025.
Much obliged.
Thank you. Next.
Item number 4, I appear for the appellant, your lordship. Mr. Bachawat is leading me in the matter. Lordship, I have instructions to seek for an accommodation.
No, we'll reject the application. Then dismiss the application. Same applies to you also. No gender bias on that.
Lordship, I understand.
You either you start it, you understand, your understanding won't do, sir. Our understanding is what matters. So we understand whatever is happening, but you have to start the matter. Otherwise, that's the only option you have. You can start the matter, we can hear the matter. You can start hearing the matter.
Lordship, learned counsel Shoruji Dashgupta is appearing virtually.
Lordship,
Yes, what is the matter?
Lordship, this is a disparagement action. Lordship,
Right.
we have filed an appeal against a part of the order which has, although confirmed the interim order, but has modified that to a certain extent. We have filed an appeal from that order, your lordship.
What is your ground in the appeal?
Lordship, the ground in the appeal is that although the learned single judge has held that the prima facie case is in my favor, and all the other points which were considered by the learned coordinate bench has also been affirmed, thereafter the order has still been modified without assigning any reasons why it
Please
should.
show us that relevant portion of the order.
Lordship, the order impugned is at page 20. Lordship would
We're
kindly
looking at the memorandum, so you can place from the internal pages.
Lordship would kindly take.
What is your name, please? Your name.
My name is Bishwarup Mukherjee, your lordship.
Yes, Mr. Mukherjee. Please let us come to that page.
Lordship would kindly take internal page 13.
Yes.
Lordship, that is the reasoning.
Demonstrate a strong prima facie.
Yes, paragraph 16. In view of the above, the petitioner has been able to demonstrate a strong prima facie case on merits insofar as the impugned advertisement is concerned. The balance of convenience and.
Who was the worst portion against you, Mr. Mukherjee? The worst portion, something to show that this order could be justified. You just preempt their arguments.
Lordship would kindly take internal page 10, paragraph 11 onwards.
We are asking for the best case against you.
Lordship,
in support of this order.
pardon your lordship.
Suppose you are the respondent and you are arguing for them.
Sure.
Show us the best portion which could be used by them to support this order.
Lordship, the argument was that the suit was filed against an advertisement taken out by the respondent.
Yes.
Which disparages my product. My product is Dabur. My product is Imami, a talcum powder of
Right.
Imami, Dermicool, as
Yes.
well as Navratna. Now, in the advertisement, a bottle was shown without the cover, but the bottle, the contours of the bottle would match the contours of my bottle, the bottle that is there in the market.
Contours of a bottle, you don't have a trademark on that.
We do not have the
Don't have
trademark, but the recall value was there, your lordship. That is what we had argued, and the learned coordinate bench had held that it is sufficient.
The color of the oil must be the same also.
The bottle, yes.
So there can be, you don't have any right over the color or the shape or contour of the bottle.
Yes, Your Lordship, but the recall value was there. So we had said that it not only disparages our product, but later on, during the course of the matter, the respondents had modified the advertisement to a certain extent.
Okay.
We said that the initial advertisement was so pervasive that the modified advertisement had a recall value, and even while looking at the modified advertisement, anyone who had seen the original advertisement would connect the same to our product. So in this order, Your Lordship,
What's the reasoning for the modification? Apparently, if you see only that paragraph, then it's in your favor.
For the modification is that the learned judge,
Yes.
while confirming the order of injunction, had said that since a lot of money is spent in creating an advertisement, so asking the party to create a fresh advertisement.
Show us that portion.
Your Lordship, that would be at paragraph. Just one moment, Your Lordship.
Probably para 11 is German, or you know better? No, para 10 probably.
Lordship, paragraph 10, there before that, Your Lordship.
Yes, wherever you want. What is this Sadharan business?
Lordship,
Ordinary or Sadharan?
yes, Your Lordship. In this,
you said Asadharan or something like that.
no, my learned friends refer to our product as ordinary or sadharan powder.
Oh, by showing your contour.
Yes, Your Lordship.
Do you, is it annexed that?
Lordship, we have the storyboard is annexed to the stay petition, Your Lordship. The storyboard.
Give us the page.
Yes, Your Lordship.
Stay petition.
Lordship, the storyboard would be at page 373.
Volume?
Lordship,
373. Very well,
373. That is annexure M, Your Lordship.
Almost got it actually. Yes.
Lordship, at page 373, if Your Lordship takes page 374.
Yes.
The second photograph, a bottle is shown, if Your Lordships may kindly see. The second photograph in the set
That
of four
greenish thing.
photographs. The white and greenish.
Doesn't even look like a bottle.
Lordship, we have produced separate photographs of the same. This is a little
smudged,
muffled,
sort of.
Smudged, Your Lordship. And in the end, if Your Lordship kindly takes, that would be at page 381.
Yes.
The second.
Oh, you have
photograph.
given all the clips.
Yes, Your Lordship.
Snippets from the video.
Snippets. And Your Lordship would kindly take page 383 onwards. A better photograph of the bottles are available there. 383 onwards.
This Cool King is there. Theirs.
Yes, Your Lordship. Dabur Cool King. That was the advertisement.
And do you have a photograph of your product?
Yes, Your Lordship. At pages 385 and 386, the product would be there. And other than that, the bottles without the jacket, Your Lordship would find at page 363.
No, with your jacket, do you have a copy of that?
With
your actual product, what it looks like. We want to see that.
No, Your Lordship. I'm not carrying the physical copy today.
No, it's not annexed anywhere because we have to compare. Comparison is essential.
Your Lordship, since they had shown the product without the jacket, we have annexed photographs of the product without the jacket.
This is what they are showing. But
Yes,
we have
Your
to
Lordship.
have an idea about what the actual your packaging looks
Your
like.
Lordship would kindly take page 365, although the outer jacket is not there, but this is
what your
Lordship might compare this with the product shown in the advertisement.
Page 363 is your product.
One of the bottles that is for Navratna, the talcum powder for Navratna.
This bottle is yours.
And yes,
actually yours.
Actually mine. And 365 is also a bottle used with respect to
where are the
another
disparaging remarks?
Your Lordship would find that at the storyboard itself.
Yes, give us the page.
Lordship would find that at page 381, where the product has been referred to as Sadharan. 381, Your Lordship. The second snippet.
What was the context of your bottle? I mean,
Lordship, in this, if
What
your
is the
lordship,
dialogue accompanying your bottle? I mean, your lookalike bottle.
your lordship would kindly take 373 and 374. The idea given was that during sweaty and humid conditions,
Yes.
a person was shown
Ah,
was
ah.
applying talcum powder, and then
They're unhappy with the results, and
so he throws away that bottle,
sir.
and thereafter embraces the respondent's product.
Let us come back to the order of the learned single.
Yes, your lordship. Lordship, the order would be at page 20.
So
of
they say that Sadharan can never be per se disparaging,
disparaging.
but he is shown to throw away the bottle. The model is
Want to throw away the bottle.
what was the original order passed? The order which was impugned before his lordship.
Your lordship,
What was the
there
first?
was no order
first
that was impugned, but the ad interim order is at page 33, your lordship.
Achha. No, he seeks a modification of the of that. Page 33.
33, your lordship.
First volume to down. It has been quoted in page 9 of this order.
Yes, your lordship. Page 33, the ordering portion is at page 41.
In view of the above, from there.
Yes, your
So
lordship.
that's quoted in page 9 of this.
Yes, your lordship.
Let us see. If they have the response.
And your lordship wanted to know the paragraph regarding the economic expenses. That would be at page.
So let us see the
30.
justification for the modification from para 9 onwards.
Yes, your
Let us
lordship.
just go through
Kindly
that
take.
quickly. Yes. So a blanket injunction was given that that bottle container could not be shown.
Could not be shown, and the product could not be referred to as Sadharan. Now, in this, the initial
If it is
part,
not shown, then by showing the bottle, then
your lordship,
Sadharan
regarding
does not count.
disparagement, we were also running.
If the
a case
bottle is not shown, there is no question of. Oh, achha, they cannot also say.
Yes, because they are not coming out with a new advertisement. They are merely just taking out a few portions, a few seconds from the original advertisement.
Very well.
Had they come up with a fresh advertisement, then perhaps the story would have been, the
So
situation
the
would have been
learned
different.
single judge modified to the extent that there shall be an interim order of restraint of the impugned advertisement, clarifying that the order of restraint is limited to the impugned advertisement as a whole. So what does that mean? They won't be able to advertise the entire advertisement. They can't show.
They cannot show the original advertisement, but at present they are still showing a modified version of the original advertisement. And that was my urgency.
So the specificity of the original order goes.
Yes.
That they cannot.
Yes, it has been diluted to a certain extent.
So let us see the.
Although the learned confirming judge has held that
otherwise,
the
yes.
He has not differed with the ad interim order.
True.
Otherwise.
Para 9 onwards, please, Mr. Mukherjee.
Lordship would kindly take paragraph 9.
Yes.
The last sentence, the primary bone of contention being that the use of the word ordinary, even in the modified advertisement, was not acceptable to the petitioner. Thereafter, the learned judge says, it is true that the concession.
So you are reading which paragraph?
Paragraph 9, the last sentence, and thereafter paragraph 10 onwards, your lordship. It is true that the concession made on behalf of the respondent at the ad interim stage to remove the bottle in the impugned advertisement and the color green is not binding. Your lordship, during the course of the submissions, the learned respondents had offered to modify the advertisement, but we were not.
That was not a final or binding thing.
Yes, your lordship. And we were not agreeable to the same because we wanted them to either come up with a new advertisement, but not continue with any portion or part of the original advertisement.
Right.
However, in view of the offer to modify the impugned advertisement by changing the unlabeled white and green container shown in the impugned advertisement, along with the cylindrical bottle, any further discussion on this aspect of the matter with reference to the impugned advertisement is academic at this stage. Once the reference to the products of the petitioner is removed in the impugned advertisement, both by color and by shape of the bottle, the only question which remains for consideration is whether the word ordinary or sadharan per se can attract any prohibition. Thereafter, the learned single judge says, it is necessary to add a touch of reality in such matters. Consumers are not ignorant. In some ways, trademark law, and for that reason, all intellectual property law is primarily meant to protect the public from confusion or deception. It is not the role of trademark law to pander to illusion and amplify the image of any product, Undoubtedly, the role of advertising or marketing cannot be undermined. The use of words like ordinary, extraordinary, exceptional, or unexceptional without any reference to a particular manufacturer or particular product are adjectives, descriptors, or attributes which only add to puffery by any manufacturer, and no rival can afford to be hypersensitive. It is also necessary to consider the context in which the word ordinary or sadharan has been used. Prima facie, the word sadharan or ordinary is being used more in a neutral sense without any negative connotation. But why that is said so, there is no reasoning in this order. An underlying interest, which also needs to be balanced, is the freedom of speech enshrined in Article 19(1) of the Constitution of India. In such circumstances, the use of the word ordinary per se, without any reference to a particular manufacturer, cannot be interpreted to be defamatory, disparaging, or offensive.
The throwing away of the bottle aspect was not considered.
Was not considered at all. Thereafter, Your Lordship, paragraph 12, there is also no merit in the case of generic disparagement. Significantly, the respondent is a rival manufacturer and distributor of talcum powders. Both the petitioner and respondent are trade rivals selling the similar genus of goods. In any event, keeping in mind the size of the class targeted, the generality of the charge, and the extravagance of the accusation, there is no basis to the allegation of generic disparagement. Thereafter, the learned single judge refers to a case law, but that was neither cited nor relied upon by any of the parties.
Please continue.
Thereafter, Your Lordship. Similarly, there is no substance in the argument that the identification in the impugned advertisement is so pervasive that even if all references to the petitioner's products are removed, the viewers and prospective customers would immediately associate and identify any modified advertisement with the petitioner's product. Admittedly, the impugned advertisement has neither been telecast nor broadcast for nearly 6 months, but a modified version of the same was being telecasted. In some cases, the creation of such advertisements is time-consuming and expensive. In some cases, it may be more practical and commercially prudent to modify an existing advertisement rather than conceive of a new advertisement. In view of the above, there is no merit in the contention of recall value, and the same stands rejected. This was the paragraph we were seeking to rely on.
Be liking to ask you some 2 or 3 questions. One is, apart from you, do you have any knowledge, Mr. Mukherjee, whether or is it treated anywhere that any other companies producing similar products with similar bottles and colors?
Similar colors, yes, but not exactly the similar bottles. We had pleaded it, and so had my learned friends also pleaded it.
Was there any picture of those?
Yes, Your Lordship.
Can we see it from this?
Absolutely, Your Lordship. Kindly give me a moment.
So that the specific reference to you,
Yes, Your Lordship.
this generality is one of the grounds of the modification.
Lordship would kindly take page 702. That would be the last volume. There are 5 products shown, Your Lordship.
But all are similar.
Lordship, but the contours of my bottle is different because there's a distinct wavy bulge in my bottle that is not found in any of the other bottles. And I am also the market leader with regards to talcum powder, Your Lordship.
You have produced statistics to show that.
Yes, Your Lordship.
What was that page again? Your bottle without the label?
Yes, Your Lordship. Just a moment.
Please just refer to that
Lordship,
page.
that would be pages 363 for one set of product, that is the Navratna product.
Yes.
And thereafter, Your Lordship, page 365. 365 for Dermicool. Your Lordship would kindly see page 365. The cap, I have a design registration on this, the cap as well as the bottle. Although not in color, but I have a design registration for both the bottles. At
That
page,
was what we were asking. You have a registration on this bottle shape also.
on the shape as well. Your Lordship would kindly take page 366. At the bottom, the wavy bulge is shown. And also at 365, Your Lordship, the cap has a distinct contour on it.
Ah. Yes.
Lordship, this is absent in all the other products in the market.
You have a design registration on the shape and color of the bottle.
On
Of the
both the
cap.
bottles. Yes, Your Lordship. It is not in color, but on the shape, Your Lordship.
Only shape.
Only the shape, Your Lordship. If Your Lordship wants, I may indicate the page numbers.
Not
Page-
right now, so we want to just be satisfied with that. Well, you want to cite any judgments? They've heard you.
Lordship, we have a few judgments. If I would be permitted to come back next week, Your Lordship, anytime after the 18th, Your Lordship. I have a leader in the matter, Your Lordship. It would be a little.
You are enjoying any interim or no? There is no scope
Lordship,
of
in the suit is proceeding, Your Lordship, and in the appeal there is no interim.
stay of modification does not mean anything. So
Yes, Your
how
Lordship.
could it be? Today we are on 11th.
Any day after the 18th, Your Lordship.
For today's hearing, Mr. Bachwat's name won't be there. We'll record your appearance. Heard Mr. Mukherjee, learned counsel appearing for the appellant. Pushed up. The matter is heard in part and shall next be taken up for hearing on the prayer of the appellant on June 25, 2025.
I'm extremely grateful, Your
Thank
Lordship.
you. Well argued. And thank you.
But I appear for the respondent. Defendant
Yes,
in the
yes.
suit. I apologize for appearing virtually.
No apologies, but give your name in the inbox.
Yes, Madam. May I only indicate whether the suit is proceeding and this specific issue has been framed and the evidence of the plaintiff is also almost concluded. This issue is there, is framed in the suit. Not followed by
You're continuing to earn money unjustly, apparently. The shape of the bottle is very.
Well, the shape will indicate. Well, there is no specific reference to the bottle at all.
Yes, yes. Very
Grateful.
so, but grateful. Thank you. The appellate side of the ticket. Disparaging the bottle. Bottle নিয়ে ফেলে দিচ্ছে রেখে সাধারণ
সেটা তো আছে।
mentioning বলুন। Yes.
My lord, I beg to mention one matter, my lord, for seeking leave of your lordship to file an appeal and to be heard on Friday, extremely urgent one. Miscellaneous appeal.
What is the
Well,
urgency?
2nd of June order, partition suit, my lord. There was an injunction order granted by maintaining status quo on 2nd of May. On 2nd of June, when it came for extension of the interim order confirmation, but that time the order of status quo has been confirmed, and subject to that he will go on construction of the building over the said property, which was the subject matter of the said property.
Difficulty is today we are on Wednesday.
Friday, my lord, kindly take it up.
Friday we sit singly. So we cannot take up this matter. And we cannot take it up before Monday. So
Monday,
we can
may it be on Monday. But I'm taking leave of your lordship, my lord.
to file without certified copy.
We filed a revision and application. Yesterday, it has been directed to be withdrawn and file an appeal. Because by mistake, my lord, it was so filed.
No,
It is
why is the leave required? You file it in due course. File it, give the number.
নাম্বারটা দিয়ে দাও, থেকে যাবে।
File it, give the number, it will appear on Monday.
As you lordship. Grateful.
We are not granting any leave, একটুখানি খেয়াল রাখবেন।
স্লিপটা দিয়ে দেন মামলাটা।
Yes.
আমি দিয়ে দেবো নাম্বার, এটা থাক, নাম্বারটা দিয়ে স্লিপটা
Now give the names of the party, yes. Name of the party রয়েছে, এটা নাম্বার দিয়ে উনি দিয়ে দেবেন। এটা নাম্বারটা উনি ভরে দেবেন।
Yes,
Please,
sure.
do that. Monday it will appear. Monday এটা order 41 এর it will appear at the top of the order 41 list. Order 41 listed top এ দিয়ে দেবেন। Bracket top দিয়ে। Yes.
My lord, may I, my lords, kindly to mention an application for contempt. My lord, your lordships kindly remember, my lord, just before the one day before the vacation, my lord, your lordship directed the child to be produced at the residence of the father. My lord, that has not been complied with. My lord, I have filed an application for
You have given a
contempt.
notice to the other side.
My lord, I have served a notice. My lord, on 16, the application is, my lord, supposed to be listed before your lordship. My lord, let these application be also listed along with the others. my
Have you
lord.
given the number of the other application?
Yes, my lord, I have indicated.
এটা ওটার সঙ্গে দিয়ে দেবেন। Very, it will appear.
To mention with regard to
I'm grateful.
appeal of 2017, my lord.
No, we are not adding.
Appeal, my lord,
We are not adding any hearing matter.
Mention this matter, my lord, before your
We
lord.
have mentioned we are not adding any appeal, sir.
Yes,
Yes.
yes, that's
Lordship,
why
kindly grant leave to mention an
you,
application.
may I, my lord,
You-
mention.
No, you may not. Yes.
Lordship, your lordship was pleased to pass an order for filing of paper book, but the appellant did not file any paper book, so we have taken out an application.
Have you given a notice to the other side? It will appear as to be mentioned on Monday.
Lordship.
Yes.
Lordship, I have filed one application for correction of the order.
Hand over. Correction.
Filed an application.
Application কিন্তু to be mentioned এ দিয়ে দেবেন
To be
applicationটা
mentioned,
সহ।
Lordship.
বুঝতে পারলেন তো?
Only the application.
Application will appear under the heading to be mentioned because it is basically for correction. Give a notice to the other side. if you
Yes,
can.
I have given the.
Yes.
My lord, for inclusion order 41 rule 11.
Come back on Monday. We are general inclusions we are taking up on Monday apart from corrections.
Yes.
Come back on Monday. We'll include.
Your lordship, I'm praying for inclusion of the matter in the daily list.
Come back on Monday and mention. Yes, call on the list.
The appeal being FAT 68 of 2020 is allowed on contest. The judgment and decree dated November 21, 2019 and December 18, 2019 respectively, passed by learned Additional District Judge, Second Court at Barrackpur in matrimonial suit number 912 of 2012 are hereby satisfied. Accordingly, the matrimonial suit is dismissed. There shall be no order as to the cost. Interim order, if any, stand banqueted.
Carefully.
Lordship, in item number 2, I'm happy on.
It was disposed of by
Yes.
mistake appeal, right? It is rightly, you are for the appellant.
Yes, Your
It
Lordship.
is rightly pointed out by learned counsel for the appellant that the appeal has already been disposed of by a judgment dated May 22, 2025, full stop. Accordingly, let the matter be matter go out of the list. Full stop. No further orders are necessary in view of the previous disposal of the appeal. যেখানে appeal বললাম and the connected application. Right. Yes, Mr. Mukherjee. Yes, start the matter. What is your name?
Bobita Praman.
Pramanik. Yes, Miss Pramanik. What is the matter?
I am for the
Mr.
applicant.
Mukherjee, you assist her. For the time being, till she is in troubled waters. Yes. What is the appeal about?
I am for the defendant appellant.
Use the microphone. Defendant appellate in a suit for?
Suit for declaration and permanent injunction.
Right. Then?
In this suit,
Suit was decreed by the first court.
dismissed
You are the defendant.
defendant.
Suit was dismissed by the first court.
First court.
Appellate court reversed that. On what ground?
Previously, suit was filed in 2001.
Can't hear you. Use the microphone.
Previously, suit was filed in 2001.
Yes.
Then this same and
Identical suit. That was dismissed for default.
Dismissed for non-prosecution. Then in 2010,
They did not prefer any restoration application,
no,
but filed the second suit.
second suit.
So it was dismissed as barred under Order 9, Rule 9.
Yes.
Why did the appellate court reverse? On what ground? Appellate court must have given some ground for setting aside. What is that ground?
Order 9, Rule 9 has to be
Mukherjee, you come up. Yes. Thank you, Ms. Pramanik. Well tried. Mr. Mukherjee, we want to see the two plaints.
Yes. Now, Lordship, initially, Lordship, the predecessor interest of the plaintiff filed a suit on the self-same plots, on the self-same cause of action. Now, that suit, Lordship, due to amicable settlement, suit was withdrawn for non-prosecution. Now, Lordship, subsequently, the heirs of the
Amicable settlement.
For amicable settlement.
But ultimately for non-prosecution.
For non-prosecution. Now, subsequently, Lordship, 2014, the heirs of the predecessor interest who initially filed a suit, again filed a second suit on the self-same plots. Now, Lordship, that suit, Lordship, considering Order 14, for the consideration of preliminary Lordship, issue, Lordship, the suit has been dismissed. Challenge the same in the first appellate authority. First appellate authority hold that this issue has to be considered on the ground of, on the issue of evidence and facts. Without considering the evidence, that cannot be asserted.
See the two plaints only. Show us the two plaints. That is the only thing.
Now, before that, Lordship, I filed a substitution application. That substitution.
Disappeal.
Disappeal.
What happened to
because
that?
One of the appellant expired, appellant number 2 expired. I file a substitution application.
This is within time.
No, there is a 520 days delay. Your Lordship directed me to serve copy.
What is the reason for the delay, Mr. Mukherjee?
Lordship, kindly come to my substitution application.
One of the appellants died. So what?
One of the appellant died.
So what could be the reason of the delay? If it was a respondent, you did not know, we could understand. You are for the respondent?
Yes. Lordship, kindly come paragraph 4, 5, and 6.
Tell us, Mr. Mukherjee, what is your story? You must know.
Lordship, residing in a remote village, Lordship, that's why, Lordship, I could not.
No, you are co-appellants. All of you reside in that remote village only.
Nothing has been stated.
No. I have stated.
Depression. Due to depression, you did not take any steps for 520 days.
And Lordship,
Not a good ground. Not aware of the procedure also. Yes, although ignorance of law is not a good defense, but we have to take practical realities. They reside in a remote village, rural area. They might not have known that this
is not a valid ground for.
Not a valid
for
ground.
the
You're
delay,
right.
Lordship.
We have to
Delay
take
should be
practical
expressed
consideration.
very specifically, Lordship. 520 days delay. The appellant died. Well known.
You are a practicing advocate.
Lordship, the one of the appellant is a practicing advocate.
Then this is sorry.
Also, let me file an application for section 5 because I have not filed any section 5.
No, we'll consider this to be an application. You file an application, take a chance before a learned single judge. This is an application. Oh, this is FMAT, so you don't have that chance.
FMAT. Lordship, let me file an application
No,
for
we'll consider
condonation
this as a composite application. We are treating this. No, not a good ground. You have asked for condonation here. Why separate
Lordship,
application?
this is a substitution application.
Don't try to escape from the court.
No,
This is a composite application. You ask for condonation of delay as well as setting aside abatement and substitution. This is not a good
problem. This is a change brief, Lordship. Immediately after getting file, I have filed. That is a Lordship, though it is not a good ground, but Lordship, let me file an Lordship, at least a supplementary affidavit because
no, we'll dismiss this substitution. Sorry. No question of that. You are an advocate. Appellant number 2 is an advocate, practicing advocate. You have claimed yourself to be a practicing advocate. How does it matter whether you reside in a remote rural area? If in your own case you do not do this, then is it credible that you don't know that substitution is required? What depression for 520 days? No, sorry. There has to be a limit to everything. No. Rejecting.
So later file a supplementary affidavit.
You will do what? You will say that no, I've left practice.
No, that is so appellant number
Unless
1 is they are all separately live.
Unless you can show that appellant number 2 has been hauled up in a bar council proceeding.
No. No,
then you are an advocate, you are a practicing advocate.
If
you do the same damage to others, you would be hauled up. So why not for yourself also? We are not sending your name to the bar council, but we are dismissing your application. 520 days. You are an advocate and a co-appellant died. What is the relation between that appellant and you?
That's a brother. 1, 2, 2. One is not one. I am the. Yes, all are brothers.
All are brothers residing in the same address.
Yes.
Then we can be liberal up to a limit. If this is condoned, then no application will ever be rejected. No condonation application will ever be rejected.
As this is a composite application along with the substitution, along with the section 5 and abatement.
Not condoning a delay in filing this. Sorry.
Now, Lordship, let me file a. Though it is an appeal, Lordship, this is a for the technical reason, Lordship.
What is the appeal against? Remand order.
Remand order.
No rights have been taken away. Contest in the.
But Lordship, kindly consider the thing that.
Considered.
Now consider the appeal on merit.
Can we? Can we? Tell us we can.
No, that cannot. Lordship, let me file a supplementary appeal because I don't know what is the reasons. At least
we know. You have stated on oath. You may not be knowing, but we now know. On the basis of your report. The present application for one other thing. Appellant number 2, this is a suit for what?
Suit for declaration injunction.
The question arises whether the whole appeal abates. You are joint owners.
Joint owners.
And the whole appeal abates.
So let me file an application for the section 5 separately.
No. The present appeal. The present application bearing Can 2 of 2025 has been filed as a composite application for substitution of the heirs and legal representatives of the deceased appellant number 2 after setting aside abatement on condonation of delay. First of next para, we find from the explanation sought to be furnished, comma, in particular in paragraph numbers 4 and 5 of the present application, that the grounds for the delay, substantial delay of 520 days in preparing the application is flimsy. Full stop. The appellants have stated that they reside in a remote village and suffered from depression due to sudden death of appellant number 2 and could not take steps to prefer the instant application for substitution within time. Full stop next para. It is also pleaded that due to lack of knowledge and their residence in a remote area, comma, the appellants could not contact with their learned advocate in time, and ultimately, after getting no objection, have handed over the documents to the present learned advocate. For sub next para, insofar as the alleged depression is concerned, comma, unless depression of a clinical nature and so severe that a person is confined to his home is established, comma, we cannot accept a general plea of depression on the demise of one of the appellants as a ground for condoning the long delay of 520 days. For sub next para, we cannot also accept the lack of knowledge part of the explanation, comma, since from the affidavit in support of the application, we find that the appellant stroke defendant number 1, comma, who has affirmed the application is himself by occupation a practicing advocate in the Rampurhat court. Full stop, thus, comma, it cannot, comma, by any stretch of imagination, comma, be said that a practicing advocate is unaware of the requirement to file a substitution application in time. Full stop, next para, moreover, comma, as rightly pointed out by learned counsel appearing for the respondents, that it is one of the appellants, that is appellant number 2, comma, a brother of the other appellants, comma, who met his demise, necessitating the present application. Full stop, we also find that the address of all the appellants is the same. Full stop, hence, comma, there is no conceivable pretext for the delay of 520 days in preferring this application. Full stop, next para, since the claim of the parties indicate that that title to the property, suit property, was claimed jointly by the appellants, comma, the appeal accordingly must abate as a whole. Full stop, next para, hence, comma, can 2 of 2025 is dismissed on contest without any orders to cost. Full stop, FMAT, we hereby record that FMAT 1125 of 2017 has abated. Full stop, no orders to cost. প্রথমেই করে দেবেন affidavit of service shall to be taken.
I beg to appear on behalf of the plaintiff appellant.
Yes.
The suit is for specific performance of oral contract with the father of the beloved defendant respondent. Now, initially the learned court was pleased to pass an interim order of injunction in my favor, in the favor of plaintiff. Thereafter, finally, the application of injunction has been dismissed on the ground, that is the impugned order hearing, on the ground that the prima facie case, the plaintiff has failed to prove the prima facie case by showing the document, a payment of rupees 1,50,000 as part consideration amount, not without considering the fact that I am in possession, and also without considering the fact the oral, in case of proof of oral contract, the conduct of the parties and the surrounding circumstances, oral testimony is required to be proved. Your Lordship, kindly come to the possession. Possession is admittedly in my favor.
You were otherwise a stranger to the property. You are not related to the defendant.
I'm not related to the defendant. My grandmother was the tenant. Thereafter, after she died, I am the possessing the suit property.
Then, Mr. Bonik, that your possession means nothing because it is in
Possession
continuance of your
Possession is admitted. Possession is
No, your possession is not in consonance. We cannot construe automatically that your possession has been handed over pursuant to that oral agreement because you are already in possession.
I was in possession, my lord, after the
Possession
death.
does not mean anything here. Possession is not an
That
attending
is one aspect, and second aspect is the oral contract. My lord, what I am trying to submit. Your Lordship, kindly have look to the impugned order first. The learned court virtually conducted a mini trial at the time of disposal of these injunction applications. Your Lordship, kindly see.
If the court the court do not give sufficient reason, we say
that
you are
the only
lacking.
point is that no document has been produced before the court to show that 1,50,000 has been deposited. But I
could be the only
admitted
proof
case
which
is that I have given the cash. I have submitted cash. I paid the cash to the father of the defendant.
one of the probable views, Mr. Boni. Let us see how the court has.
Your Lordship kindly sees the page 4 onwards, my lord, the inner page 4.
Page 4, yes, we are there. They said that you are a trespasser.
Yes, that is their case.
Okay. Your case is that your grandmother was.
Yes, my grandmother was tenant. Thereafter, my lord, I am possessing the super. I was living with my
When did she die?
She died, my lord, 22nd of June 2022.
You are a dependent of your grandmother.
I am, yes, only sole dependent.
You are
sole. My lord,
she was your dependent, or you were
no.
her dependent?
But I was residing. She has got no heirs. I am the only heirs of the.
That does not make you a dependent.
No, that is not dependent. Not dependent.
Then in any event, I mean, 2022 is after 1997.
Your Lordship kindly consider this is a.
Then, as per your case, you don't have a right.
This is, my lord, the oral
But
contract.
this is not an eviction.
Oral contract, my lord. Your Lordship kindly consider this aspect. Oral contract is required to be proved in some other else, not in regular manner, my lord. And that is to be proved in the trial.
True, but does not mean that as a matter of right, if you file a
No,
suit.
no, I'm not matter of right, my lord. That
oral contract, two major indicators, Mr. Bonik, as you rightly pointed out, is one is that consideration and possession. If possession is handed over to you, pursuant to that contract.
Yes.
But here your
possession is there.
Your own case is that it was already there.
Yes, possession is there, and my lord
cannot be connected with the
Your Lordship kindly sees my application for injunction. I prayed for, my lord, not to alienate the property and not to disturb my possession. The learned trial judge hold that this possession is with me, although it has been stated that I am the trespasser in the property after the demise of my grandfather.
It is rightly held, Mr. Bonik, that you have failed to prove prima facie case that you have not produced a single scrap of paper. That is a finding.
With regard to payment, my lord, I specifically my case is I paid cash. I paid cash.
Cash also you require a receipt as per law.
So that is not there. Your Lordship, why? What happened, my lord?
1,50,000 you give without receipt.
Why this happened, my lord? Second of July 22, yes. The oral contract was, my lord, entered into, and thereafter 30th of September 22, the father died. Why, my lord? The amount has been taken from me. The father has proposed me that since he is suffering from illness, this money is required. And he promised me to execute that sale deed in my favor if I pay him 1,50,000 out of 17 lakhs. And the agreement, the specific abatements have been recorded in my plain, my lord, the agreement, which are the clauses which has been agreed by the father of the defendant. That has been, my lord, gone down in the my lord, plain itself. So Lordship kindly sees my prayer once in my application.
No written receipt of the payment.
Nothing is there, my lord. That is fact. That is fact. That I have, my lord, if
nothing
I have
to show that you ever requested that sale.
That is, my lord. That
in
is why, my lord, at the very outset, my lord, I stated, my lord, this is oral agreement.
Everything oral, then we'll orally reject.
No, my lord, that is to be proved, my lord, in conduct course.
We'll orally dismiss your appeal and then reduce it to writing.
Your lordship knows, my lord, course of dealings, conduct, my lord,
yes,
and other, my lord, surrounding circumstance, and my lord, the oral testimony. That is vital, my lord. These things are vital.
This is a new ploy to prevent your eviction.
Your lordship kindly sees me. I am in position. That is admitted. That is admitted. So my prayer was, one of the prayer was not to disturb my peaceful possession, because they are trying to oust me.
A prima facie case, a legal right. They say for a trespasser.
That is true.
Trespasser can get an injunction except the true owner, against the true owner.
Lord, my prayer was there. Your lordship kindly sees my.
They are the true owner. You are admitting them to be an owner. They are saying you are a trespasser. In any event, your suit, the injunction is in aid of the suit.
Yes.
Your suit is not for declaration of anything, or
not for declare.
It is for specific performance. You have failed to prove any oral agreement. Yes, we understand that oral agreement has to be proved in evidence.
Yes.
But something has to be there at the injunction stage also. You say you have paid 1,50,000 as advance. No document, no scrap of paper, as the court
No,
said.
Milord, what
You
happened?
have
Milord?
requested many
I
times
have,
for
Milord,
2 years, no written
I have
request.
my document with me to produce before the court at the time of trial that after the death of my my grandmother, I have changed my name of the electric meter box. I renovated the flat, which is the subject matter of the property.
That is in furtherance with your
Yes,
trespass.
that is these are
That
these
does
are
not mean there is a contract for sale.
no, that is true. But this will come before at the time of trial. So what happened thereafter, after the payment of the
Let it
cash?
come at the time of trial. For the time being, be content with this.
In the meantime, if I am out from the property,
One of the worst cases you are moving with.
there is no application. No suit for eviction even been filed, by them.
They will thank you for that.
No, that is why, they are trying to oust me from the property. Your
It
Lordship,
has come to Mr. Mukherjee now. Rest assured that it will be filed before the end of the week.
No, Your Lordship, kindly protect me
Counterclaim.
on.
No.
Your Lordship, kindly come to my prayer at least, Milord.
We are not the first court even. I mean, a very valid view has
First
been
court.
taken by the trial court.
This is the second court, Milord.
Yes, that is why we are not the injunction court, the suit court. So we are sitting in appeal over a particular order. Where is the illegality in this order? Perfectly justified order.
Only thing is, Milord, no document has been produced to show that payment has been made. But my categorical case is that payment made by cash. In hand.
And God, you have not said that payment was also made orally.
I cannot believe.
Like Shivram Chakravarti's that story, that sound of the coin was the fine. No. Sorry, Mr. Sorry, Mr. Mukherjee, for not giving you opportunity to argue that. Mr. Bonik, you have tried your best. We are sorry.
Only thing, my lord, the oral contract has also not been pleaded in the plea.
They have said there is an agreement.
That's all. And second, they have also pleaded that they were contemplating criminal action against me. And after that, they're claiming that I have taken money for which they have not taken receipt.
We'll not go into that. We will not prejudice the trial so much. We'll just affirm this order. The present challenge has been preferred by the plaintiff in a suit for specific performance of contract. Full-stop. Learned counsel for the appellant submits that the learned trial judge dismissed the injunction application without considering that the plaintiff case refers to an oral agreement to transfer the property in favor of the plaintiff stroke appellant, and such agreements are to be gathered from attending circumstances. First up, it is submitted that since the plaintiff case is specific as to such agreement having been entered and consideration having passed without any receipt, the learned trial judge ought to have granted an injunction to protect the property till disposal of the suit and grant an opportunity to the plaintiff to prove the plaintiff's case by way of due evidence at the trial of the suit. Full stop. Next para, learned counsel for the appellant harps on the issue that the appellant has been in possession of the property, which also indicates that such possession was pursuant to the oral agreement for transfer. Full stop. Next para. However, in the same breath, learned counsel contends that the appellant, being the grandson of the original tenant, has continued in possession of the property. Full stop. Next para, we also find from the impugned order that the defense case was that the appellant is a rank trespasser in respect of the property. Full stop. Next para, even going by the plaintiff case, since the appellant claims to have continued in possession as a tenant on the demise of the original tenant, his grandmother, possession cannot be a determining factor to prove even prima facie that such possession was handed over pursuant to any oral agreement of transfer. Full stop. Next para. Insofar as the impugned order is concerned, we find that the learned trial judge has adverted to the materials on record and the pleadings of the parties and has applied the correct yardsticks, including taking into consideration the fact that despite having alleged that consideration of rupees 1,50,000 was paid, comma, not a single scrap of paper has been produced by the plaintiff stroke appellant to substantiate such passage of consideration. Full stop. Next para. The learned trial judge also observed in the impugned order that allegedly the agreement for sale was made on July 2, 2022, and the father of the defendant died on September 30, 2022. Full stop. In the long 2 years between the filing of the suit and the alleged agreement being executed, comma, the plaintiff has failed to produce any document to show that there was any request from the plaintiff to the defendant to complete the sale transaction. Full stop. Next para. On such findings, comma, the learned trial judge arrived at the conclusion that the plaintiff has failed to prove prima facie case for grant of injunction. Full stop. Next para. Moreover, comma, the learned trial judge observed that the injury likely to be caused to the plaintiff, comma, if at all, comma, would be compensated in terms of money, and as such, on such score as well, comma, the injunction was refused. Full stop. Next para. Since the learned trial judge has taken a plausible view, comma, applying the test of preponderance of probabilities, comma, we are of the opinion that there is no scope of interference with the said order. Full stop. Rather, comma, we would like to appreciate the way in which the learned trial judge adverted to all the relevant materials on record and the governing law and came to reasoned findings on the injunction application of the plaintiff stroke appellant. Full stop. Next para. Accordingly, FMA 757 of 2025 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure. Consequentially, Can 1 of 2025 stands dismissed as well. No rest to cause. Sorry, sir.
But I'm appearing on behalf of the respondent number one,
Well, I
although I have not been served yet. Under instruction, I'm appearing, my lord.
Have you lodged a caveat?
No, no, there is no
Even
caveat.
I was not, I don't know whether
No caveat, no
served
caveat.
with the order of the court, Learned Court below or not, because this matter has got a checkered history. They have preferred police
The
inaction.
challenge is against what?
Well, an interim order of injunction has been refused, my lord. Against that, I am before your lordship, my lord. They have not lodged any caveat, my lord. So, if your lordship allows me, I can place the case, my lord.
Give a copy since he's appearing.
Well, only urgency is that, my lord. Well, this is a case, my lord, wherein, my lord, I have purchased a property through PNB Bank Finance, my lord. That was mortgaged. And after that, my lord, what I have found, my lord, that there is the some of the property, some portion is, my lord, under the vested property. Whatever that they have claimed, not vested, it's not decided now. Well, we have not the Hitco is claiming that some of the portion has been encroached, which is a vested land.
You purchased the property?
Yes, I purchased through bank finance. Now,
bank finance is not so sacrosanct.
Yes, because the searches has been made. After that, you get the fine. Yes.
Good.
Now, what has happened? I immediately came before this honorable court. I filed a writ application for demarcation of my property.
You are Hitco?
I'm the
bank.
Finance.
Bank. Now, I have only obtained an order of.
What is the suit for?
A suit for injunction that, my lord, the secured property is a different property, and this is my residential house. The bank cannot, my lord, put a charge on this property, my lord, without, my lord, having a sufficient proceeding in respect to the secured property. My case is totally different, my lord. I am not on respect to the secured property. Secured property is there, my lord. The bank can always go and proceed. This is my residential house. I am living with my
So, what
family.
is the question of your apprehension then? If this is not the secured property?
No, they have now what they have done, my lord. I'll just take your lordship's 2 minutes of time, my lord.
No, take your time.
Yes, ma'am. Now, if your lordship takes the order of.
Let us hear it under Order 41, Rule 11, because they have urgency.
Yes.
We are continuing to hear that.
Yes.
You take your seat.
Now,
If you admit it, then we'll direct this.
Now, my lord, this honorable court, my lord, passed an order of demarcation. The demarcation has to be made
in a writ petition.
Yes, in a writ petition, my lord. Till the pendency of the demarcation, my lord, the order was that, my lord, if it is found the land is vested, then the bank can proceed under the surface proceeding, my lord.
If the land is found, it's a vested. Now, demarcation proceeding is still pending because there are certain because a big area, it's near Causeway. Yes, it's a 5.
Vested.
What has happened, total land is 5.6. I have purchased 3 kata and 3 kata, 6 katas of land. Now,
from an individual.
Yes, from an individual. Now, what has happened, HITCO, one fine morning came and put a board on my property. I immediately made searches, and everything is on record because I purchased through a bank, from bank. Now, immediately, PNB bank.
Through bank, not
Through
from bank.
Correct myself,
Bank only financed you.
Yes.
So you're now trying to stall the SARFAESI proceedings.
No,
right?
I never, But I am on the point that if today
Is the mortgage deed?
Yes. Well, not mortgage. Lordship will kindly take the order of this honorable court, and then I'll proceed with the case. Lordship will kindly takes,
No, we want to see from the mortgage deed that this is not the secured property.
This is not a secured property. That they can also, my learned friend also cannot deny that,
They cannot deny or admit because he doesn't have a copy of it.
Well, I'll just show, Lordship will kindly takes, Yes. Yes.
Why don't you give a copy and come back, Mr. Chatterjee?
Very
Because
well.
then we can, even if we dismiss, it's a different thing. But if we admit it, then we can dispose of the appeal probably also. Your learned friend is very reasonably have seen in other matters.
Yes.
So you take instruction, appropriate instruction, give a copy today.
Instruction is that the property was purchased from an individual.
Yes.
Each and every record is showing in the name of that individual. Now, what they are alleging that I have not caused proper searching before financing this transaction.
They are seeking a damage against you also.
No. Totally different case.
Stand is
They are saying this is not a secured asset. What is your stand?
instruction as well.
No, is this a secured asset? The secured property
So far, this
is not.
No, my lord. I am not aware what property they are seeking.
Yes, this is a residential house.
You must have instruction. You must have a copy of the plaint.
My lord,
In lodging a caveat, you have to have a copy of the plaint.
This is police in action because they are a checkered history, my lord. They have preferred many litigation.
We have also given.
Give a copy, please take instruction whether this is a part of the secured assets. The court said what? That it's not a secure.
No, court said we do not have any urgency, my lord, and for that reason we have come from this.
What is the nature of injunction? Let us see that also.
What will kindly take, my lord? Page.
We may come back tomorrow if I get.
Yes. Not tomorrow, Monday, because tomorrow we take up hearing matter. Yes, tomorrow. In fact, it will be in the list tomorrow. If
Yes,
for some reason the hearing fails, then we'll take.
Disturbing peaceful possession and not to transfer. And already this property.
Give a copy.
And more interesting thing is this property is mortgaged with ICICI Bank. This is my residential house. It's a totally different property. So, whatever they are proceeding, and I'll show you from the RDDB Act, if the bank fails to get the money from the secured asset, then he can proceed under the SARFAESI proceeding. Not
So you have failed your loans with this bank as well as the IT.
No, this is my residential. I'm paying. There is no dispute in respect to that. My case is that this is my residential house. That was for I purchased for to build a showroom, so that
that regarding that you have failed. Must have failed.
Yes. Because I have not failed.
Give a copy.
I'll give a copy.
What is your full name, please? I forgot. Ganguly. The names we remember, but we have to have to the name, the surnames only. Mr. Ganguly, Mr. Shayak Ranjan Ganguly, having instruction to appear on behalf of the respondent bank, seeks a copy of the injunction application. First of all, although there is no caveat, comma, for the ends of justice, the learned advocate for the appellants is requested to hand over a copy of the memorandum of the appeal as well as the connected application to Mr. Ganguly during the course of the day. First up, let the matter be adjourned till tomorrow when it will be listed under the same heading.
Instead of Monday, it can be taken on Tuesday. Monday.
It will remain in the list tomorrow. Tomorrow probably it will not be reached because we have hearing matters.
Yes,
Unless you have a strike regarding hearing matters or something like that.
Get
Yes. Give a copy of the memo as well as the.
Yes, I'll send.
Because he can take instructions. Yes.
7 Milord, I appear on behalf of the appellant. When a suit for partition, three of the defendants are the appellants before my lord. I have come up against a rejection of my application under Order 39, Rule 4. Now, my lord, my predecessor, my lord, purchased the share of one Shamoli in a property and thereafter purchased the rest of the shares from all the other co-sharers, became 100% owner in respect of the suit property. In the year 2000, In 2010, the plaintiff claims to have got this property from the same Shamuli by way of a deed of gift. When I came to know about this,
That's a subsequent deed of gift.
yes. When I come to know about this, I file a suit for cancellation of this deed. I filed, my lord, a criminal case. In criminal case, charge sheet is filed. Charge sheet is filed. Thereafter, this suit is filed through an attorney.
Criminal case saying that it was a fraudulent deed.
It is a one that
it is one thing to say that despite having sold to you, she has sold to him.
It's not my case, my lord. I cannot go travel beyond, my lord, what I have stated in my WS. I am saying that it did not confer any valid title.
Yes, in the civil suit, that is the most. I mean,
yes. Now, this knowing all these things in 2024. Lord, the plaintiff will not files this suit through an attorney, simpliciter saying that I am the owner in respect of the property by dint of the deed of gift.
No injunction sought.
He files an application for
suit is for what? Declaration.
Suit for partition.
Suit for partition.
Partition as against the co-owners from whom I have purchased.
You have purchased from all.
I have purchased from all. So all those persons are implemented.
He has purchased only the share of Shamuli.
He has purchased
the first vendor, your first vendor.
He has.
You purchased from Shamuli first, then the other co-owners to enter property.
Yes.
He purchased.
He got a deed of gift.
Got a deed of gift subsequently from Shamuli only.
My.
And therefore he has filed this partition suit saying that he has.
Simpliciter saying that I am the owner in respect of 1/6 share of Shamuli by dint of this deed of gift. Does not say anything about the earlier suit filed by me.
There was an earlier suit for?
I filed a suit for cancellation of his deed of gift.
What happened to that?
That is pending. That is pending. Does not say that the criminal case is pending. Now, whether this was a relevant fact to be disclosed or not, he got an ad interim order of injunction. I filed, my lord, an application under Order 39 Rule 4 disclosing that these are the suppressions. Well, the court, my lord, has arrived at a conclusion that there is no suppression.
He had arrived, he had entered appearance in that suit, your suit.
Yes, yes.
No.
Summons have been served.
My instruction is.
You will hear it. Yes.
Summons have been served, and in the criminal case, charge sheet has been filed. So he knows about the factum of the earlier deed being in existence, and
it is in his favor.
The deed is no,
your deed. Sorry.
My deed. Lord, the learned court, my lord, has arrived at a conclusion that there is no suppression of any relevant fact.
Mr. Chaturvedi will admit this appeal. Will admit this appeal, but we will hear it on the papers which are already on record.
Yes.
Are all the relevant papers on record?
Only one thing, my lord, I have referred to my application under Order 39 Rule 4 in my stay application, but inadvertently, my lord, it has not been annexed. So I have.
That has not been annexed. That is the.
My lord, I have, my lord, prepared, my lord, a supplementary affidavit to my stay application.
We'll take that supplementary affidavit. We'll ask you to give all copies, including memo to Mr. Dhar. And we'll come back. We'll take up the application along with the. We'll admit the appeal right now.
My lord.
We'll take up the appeal and the application next week.
As your lordship pleases.
Week after next. Week after next, we'll fix a date and on that date.
Now, my lord, only one more thing, my lord. My Order 39 Rule 4 has been rejected, but the Order 39 Rule 1 and 2 is still pending. What remains in that is a question that I pose to myself. Both the applications were on the board. Both the applications should have been heard together.
The 39.4, Mr. Chaturvedi, is on a different yardstick than 39.1.2. You can have your 39.4 rejected, but still get an order favorable.
Get his application rejected. I say could have. I say, both the applications could have been, and normally that is what is done, Millard. Normally that is what is done.
You had filed your objection to that.
I have filed my objection
to the injunction application.
To the injunction application.
Should have been.
Now, Millard, only one more thing, Millard. When Millard, I file my Order 39 Rule 4. Millard, and the plaintiff comes to know that about these things, Millard, being brought on record, he files an application for amendment. That amendment is not yet allowed. The learned trial court, although...
So even if that amendment is allowed, even if it relates back to the date of the filing of the suit, then also at the relevant point of time, there would have been suppression if otherwise there is suppression.
Millard, and the learned, I'm grateful to my lord, the learned trial court has relied on
Amendment application.
Amendment application. He has looked into the texture of the suit after amendment. Lord, kindly, my lord, seize the order for a moment and lord, subject to my lord's kind sanction. My lord, kindly comes to page 77. That is the impugned order. And I take, my lord, directly to the relevant portion, my lord.
Yes.
The rest of it, my lord, I have already, my lord, submitted. Lord, kindly seize page 83. So the last paragraph.
Yes.
Thus, from the above discussion, it is crystal clear that deliberate suppression of fact or misrepresentation would disentitle a party to any discretionary relief. But say deliberate suppression of material fact or misrepresentation should, in regard of material fact of the case, that is material for the purpose of determination of the suit. But in this case, which we are dealing at present, there is nothing on plain as well as in the injunction.
Yes.
In the injunction application, which shows that the plaintiff have deliberately suppressed any material fact or made any misrepresentation in order to obtain the impugned order from this court. Moreover, in the alleged deeds number so and so, in the deed of predeceased in interest of the predecessor in interest of the defendant 20 to 22, as well as the deeds of the defendant number 20 to 22, plaintiff is not a party. And in this aspect, it's a specific case of the plaint that the said Fuli Mondal, Shamoli Ghoshal, was a minor when she, along with Rashmoni Mondal and Ranjit Mondal, allegedly sold the land to my client. This, Milord, is the subject matter of the amendment application which is pending. This factum is sought to be brought.
And this was not a part of their injunction application, not a part of the injunction pleading.
No.
This
fact is sought to be brought on record by filing an amendment, which is now fixed for hearing on the next day, which is on. May I, Milord? I'm told it was 17th or 18th, Milord, of this month. After 16/5.
No difficulty. At the time, we will consider the relevant time when the injunction application was moved and the order was moved, even if the amendment is allowed. The present appeal has been preferred against the dismissal of the appellant's application under Order 39, Rule 4 of the Code of Civil Procedure for vacating an ad interim order of injunction granted in favor of the respondents, primarily on the ground of suppression of material facts. We find a sufficient arguable case having been made out by the appellants, inasmuch as a question arises as to whether the ad interim order of injunction was obtained by the plaintiffs / respondents by suppression of a prior deed in favor of the appellants, as well as a pending suit instituted by the appellants challenging the gift deed of the gift deed in favor of the plaintiffs / respondents. Next para. The appeal is accordingly admitted and will be heard on the grounds taken in the memorandum of appeal and the questions as formulated above. In view of the relevant documents being substantially on record, we intend to hear out the appeal along with the application on the materials already on record before us, without calling for the records. We dispense with formal preparation of paper books. You're ready with that supplementary affidavit? Leave is granted to the appellants to file a supplementary affidavit, which is kept on record, which is filed today and kept on record. Next para. Then we'll have to give them an opportunity to use opposition to this.
This is not their application.
If all the documents are annexed, then we'll say that we are not. You are not admitting it. So next para, accordingly, can 1 of 2025 along with the appeal shall be listed for hearing under the heading application on June 23, 2025. The appellant shall serve copies of all the memorandum, the application, as well as the supplementary affidavit.
No, already done.
Supplementary affidavit also?
Yes.
Since the appellant has already served copies of the memorandum of appeal as well as the connected application and supplemented affidavit on the learned advocate for the respondent, plaintiff's respondents, further service is dispensed with. Full stop. The appeal be treated to be ready as regards service and otherwise. It's come back.
Will my lord
23rd.
pleasure be, my lord, that the suit be set because next date is fixed for order 6 rule 17, my lord.
No, any order passed in the suit, in the connected suit, in the meantime, shall abide by the outcome of this appeal. So we make it abundantly clear that in the event any adjudication is made on the pending amendment application of the plaintiff's respondents in the court below, in the meantime, the position as on the date of passing of the impugned order shall be construed irrespective of the outcome of such amendment application. We make that clear also. Take up the next matter. This matter.
Lordship, I am appealing on behalf of plaintiff, appellant, Lordship. Lordship, this is a suit for partition and injunction, Lordship. Lordship, this is the undivided, unpartitioned, undemarcated portion.
Right.
Lordship, defendant number 1 to 7 are the stepfather, brother, and sister of my deceased grandfather. Because my deceased grandfather has 2 wives, and in first wife's son, and thereafter we inherit from
The two marriages were before 1956.
Yes.
Well,
Thereafter, Lordship, this is undivided, unpartitioned property, Lordship, and we made for partition primarily, but that was turned down. Then I have the defendant number 1.
What was turned down?
When Lordship, when we have amicably partition, we proposed for amicable
File the partition suit.
Yes.
What?
Thereafter,
the
Lordship,
what?
Lordship, I have filed that ad interim order was refused by the civil judge senior division Ranagat Nodia, because that I have no prima facie case at all, because this is undivided. But Lordship, the learned court assured that this is unpartitioned property, undemarcated property, and they constructed defendant number 1, 2, 3. They constructed and transferred to change, alienated their portion without consent or without taking any consent from me. But they refused ad interim order of injunction, and we are suffering. And they started construction, Lordship, in vacant land, and now plus 2 floors, second floor is going on, and plaster. What
is the nature of injunction you asked for? That is a prayer. Have you annexed the injunction application filed in the court below? The intent the injunction application are the minimum things which you should annex in your application.
Lordship, this is the plain, Lordship. I believe, Lordship, this is the plain, Lordship. And
you have not annexed the plain and the injunction application to the stay application. What shall we look into to ascertain whether the learned trial judge was correct? You are just handing up copies. So many things you have annexed without this. Let us see the plain and the injunction application filed in the trial court.
This is the copy of plain, Lordship.
Where is the injunction application? This order has been passed on that injunction application. You don't have a copy of that. Are we to believe this? How did you drop the memorandum of appeal?
Lordship, this is the photocopy, Lordship.
Not the photocopy, this is a photo.
Photo, yes, Lordship. This is the photo, and I have annexed
the photo with you. We are not interested in looking at how the premises look.
Lordship, kindly impugn order first, Lordship.
You have already read the impugn order.
And Lordship, moreover, Lordship, defendant number 7, he's a mentally disabled person, and practically they deprive his share also.
Is it represented by next friend?
Yes, Lordship. This is represented by.
Yes. The present appeal has been preferred against the refusal of a prayer for ad interim injunction in a suit for partition filed by the plaintiff stroke appellants. Push up next para. Sorry, plaintiff stroke appellant, singular. Push up next para. In the impugned order, the learned trial judge observed that the plaintiff has not been able to show at this stage that there is reasonable apprehension that the alleged acts of the principal defendant numbers 1 to 3 shall cause irreparable loss and damage to the suit property or infringe his right as co-sharer of the property. It is further observed in the impugned order that the plaintiff is not in exclusive possession, and only if a co-sharer is in exclusive possession of a property, he is entitled to injunction against the other co-sharers. Push up next para. Prima facie, such findings are based on erroneous premise, since at the ad interim stage, it is only the abatements of the plaint and the injunction application which are to be looked into by the trial court. Push up that apart, it is an unknown proposition of law that a co-sharer is entitled to injunction of the nature as sought herein only if he or she is in exclusive possession of the property. Full stop. Rather, it is the it is a well settled proposition of law that in suits, in partition suits and suits of like nature, the endeavor of the court would be to maintain the property in statu quo till disposal of the suit. Full stop. Next para. Hence, we are convinced that the petitioner, the appellant stroke petitioner has made out a prima facie case. Sorry, the plaintiff stroke appellant has made out a prima facie case for grant of ad interim injunction. Full stop. Accordingly, the appeal is admitted and shall be heard on the above grounds and the other grounds taken in the memorandum of appeal. Full stop. The respondents and/or their men and agents shall remain restrained by an order of injunction from selling, transferring, alienating, and/or encumbering and stroke or parting with possession of the suit property in favor of third parties in any manner till disposal of the application. Full stop. The appellant shall serve copies of the application as well as the memorandum of appeal on the respondents, indicating that the application shall next be listed on in the monthly list of July 2025. Full stop. The appellant shall file an affidavit of service in that regard on the next returnable date. Please hand over a copy of this plaint during the course of the day. We are returning it to you, but hand over a copy during the course of the day.
Yes.
Give it to our officer before recess.
Yes, Lordship.
Delay
Yes,
to ঢুকিয়ে দেবেন।
obviously.
On top of it, just write this FMA number, FMAT number.
Yes.
So that it is.
But I'm for the appellant.
Yes.
The defendant number 1, 2, 4, and 5 is the appellant before your lordship in a suit for partition, my lord, initiated in respect of a property, my lord, which is in the nature of Kala, my lord, in Paschim Medipur, which is an agricultural land. Now, my lord, it's a case of the plaintiff also that both the parties are there in mutual separation. They are cultivating the land by making my lord, in between the properties. Now, my lord, the order has been asked for so that, my lord, the status quo to be maintained. The learned judge, my lord, without, my lord, considering the case even made out by the plaintiff in the
Status quo
plaint,
has been sought, not injunction.
injunction has been sought for. The learned trial judge granted status quo. All respect, nature, character, possession, transfer, alienation. But transfer, alienation, we could have understand. When the all co-sharer are cultivating, that is the case made out by the plaintiff. How the nature and character, by virtue of nature, character, I am not even able to cultivate the land or to cut out the crops we have already been cultivated over the property in question. It's the case made out by the plaintiff also, that all of them are. And there are other point also one, but that is curable. Where we have pointed out specifically that defendant number 6, after filing of the suit, already transferred the property in favor of some third parties. So they are necessary party, but the learned trial judge to some extent has stated that this can be done in future.
Nature character, you reaping your crops does not tantamount to changing nature character.
If kindly see, both the parties are directed to maintain status quo in respect of nature, character, possession, and transfer. But I am only with regard to that clarification. Otherwise, my lord, by virtue of this injunction, my lord, we are not even able to, my lord, cultivate our own land.
Mr. Mukherjee shows their admission that
Yes, my lord, kindly takes up the can. My lord, can 1, my lord, the plaint is being annexed, my lord, page 14. Kindly takes up paragraph 3, my lord.
আপোষ অংশানুযায়ী তত্ত্ব দখল পরিচালনা করিতেছে
এবং কত তপশিল সম্পত্তি কদাপি বাই মিটস এন্ড বাউন্ড স্পেসিফিক পার্টিশন হয় নাই, বাদীগণ আপোষে তপশিল সম্পত্তির একের অংশ
alleging that মাটি কাটি আরম্ভ করিলে.
So that's why, it's a cultivated land. So what is their intention is to stop us from cultivating the property. There lies the difficulty.
There are bamboo trees and other trees also.
There are
cannot
restrain us from cutting the trees, but regarding the cultivation program, that cannot be stalled. That is the only livelihood of the defendant also. Restrain us regarding the transfer alienation and also from cutting the trees, branches of the trees. I am not on that, but regarding the cultivation. But in any event, since an injunction has been passed, I will have to serve and come back, because without hearing them, your lordship.
The present appeal has been preferred against an order whereby status quo as regards nature and character, possession and transfer of the suit property has been granted in favor of the plaintiff stroke respondents numbers 1 to 3 in connection with a partition suit. First of learned counsel for the defendant numbers 1, 2, 4 and 5 stroke appellants argues that it is an admitted position even from the plaint that both sides are cultivating the property and the suit property is a cultivable land. Full stop. Next para. It is submitted that by virtue of the status quo granted by the impugned order, the appellants would also be restrained from reaping the crops harvested on the said cultivable land as well, thereby striking at the very root of their livelihood. Full stop. We find a prima facie case for hearing of the appeal on merits having been made out, inasmuch as it is arguable as to whether by operation of the impugned status quo order regarding nature and character and possession, the parties would also be restrained from harvesting the crop sowed SOWD on the suit property. Full stop. Accordingly, the appeal will be heard on the above question and the other grounds taken in the memorandum of appeal and is hereby admitted. Full stop. The appellants shall serve copies of the memorandum of appeal as well as the connected application on the plaintiff stroke respond numbers 1 to 3, indicating that the application shall next be listed on June 23, 2025, when an affidavit of service to that effect shall be filed by the appellants. Full stop. Service of notice stroke copies on the pro forma respondents 4 and 5 is dispensed with for the present. We're not granting an interim order at this stage.
I cannot.
Yes.
But pursuant to the order passed on 6th of May, I am filing the affidavit of service as regards the service of substitution application. On 6th of May, my lord.
Just properly served. What do the envelopes say?
The person who is died is respondent number 4. The envelope as regards the legal error of respondent number 4 has returned back with an endorsement left.
Left and insufficient address.
Insufficient address as regards one of the other respondents who are previously served with in the said address. And now, since the legal error of the person who the died person has come back with the endorsement left, now substitute service otherwise, because it is the substitution application, my lord. Can 4 and can 6 may be taken up prior to other applications, because can 4 is for expunging the name of appellant number 1 who died, and
appellant number 1 has died. His heirs are already on record.
Already on record. Or
can
4 of
4 let us allow right now. 4 of 2025. Can 4 of 2025 has been filed for expunging the name of appellant number 1 who has died during pendency of the appeal. Full stop. We find from the application that the same is otherwise informed and that the deceased appellant number 1 has already left and that the heirs and legal representatives of the deceased appellant number 1 are already on record in the appeal. Full stop. Accordingly, can 4 of 2025 is allowed, thereby expunging the name of the appellant number 1, Srimati Shanti Polle. Full stop. There will be no address to cost. The learned advocate on record for the appellant shall carry out the necessary rectification in the cause title of the memorandum of appeal and the other pending applications by deleting the name of the appellant number 1 Your advocate on record is there?
I'm the advocate.
You're there. During the course of the day. Full stop, the affidavit of service filed today be kept on record. Full stop, it transfers therefrom that proper service could not be effected and the envelope sent to the parties have returned unserved. Full stop, next para. Accordingly, on the prayer of the appellants, comma, the appellants are directed to effect substituted service by substituted service of the appeal and the application of the applications by way of newspaper by way of publication in 2 daily newspapers, comma, 1 in English and 1 in Bengali vernacular, having substantial circulation in the area of the last known address of the respondents. Full stop, next para. An affidavit of service indicating such substituted service having been effected shall be filed on the returnable date. Full stop. The pending applications shall be listed together for hearing next in the monthly list of July 2025. You carry out that substitution application in the meantime, the substitution,
And
the substitute service in the meantime?
in the course of today, I'll correct the cost.
Yes, that you do. In the pending application as well as the memorandum.
My lord, the advocate on record for the applicant had to leave court due to some personal difficulty, so kindly make it not today.
On the prayer of the appellant, the matter is adjourned for the day.
My lord, in this matter, Mr. Dolopati is appearing. He's out of station. He reached today. He is on way. My lord, kindly.
He is a secretary of the bar. Even if he is out of station, he is notionally present in court.
Kindly
So we'll
fixed
take
at
up the matter.
2 p.m. At least. Kindly fixed up 2 p.m.
2 p.m. Yes, what do you say, Mr.
My
Mahathir?
lord,
2 p.m.
My lord.
Very good. Pass over for that at 2 p.m. There is a section 5 application also.
There is section 5 application.
We'll take it up at 2 p.m.
My lord. 12 to 23.
12 to 21.
21.
12 to 21 all will
My
be
lord.
taken up at. This is acha,
My lord.
land acquisition.
Land acquisition.
My lord,
Yes, Mr.
I am appearing for the petition
Right.
appellant on behalf of husband. My lord, my prayer.
Anybody is appearing for the respondent, Mr. Moitra?
I find, yes. I was,
What is this for removal of padlock and?
I purchased one flat. Now, my lord,
Mr. Moitra, please tell us, this appeal is at your behest against a decree of divorce or refusal?
refusal. So, my lord, service was again that one.
Service was directed.
No.
Of your own, if you serve, we
Yes.
have to direct fresh service.
But I find,
There's the direction for service.
yes, my lord.
Was there any direction for service? Just let us check up.
No, my lord, perhaps one of the details.
No, we don't find it.
Sorry, my lord, it was served at my inn.
Served, but without any direction of code, Mr. Muthu. Removal of padlock, please serve and come back
My
again.
lord, they received, their lawyer received.
If they appeared, we could have taken up.
My lord, I was.
You know, Mr. Muthu.
ঠিক আছে
Who is their lawyer?
এটা কি
Then we'll just ask you to, you will take the affidavit of service on record and we'll just request you to serve a notice to her and we'll take it up on Monday. You file a receipt of that,
yes.
receipt you file on the next day. If they don't appear, just serve on their advocate. Since the respondent wife is already represented through her learned advocate, comma, the learned advocate for the appellant is requested to serve a notice to his counterpart appearing for the respondent wife, indicating that the application shall be listed for hearing next on June 23, 2025. And file a receipt on the said date. Full stop. Next para. The affidavit of service filed today be kept on record.
I have served also upon the respondent wife. By
On the
post
officer in charge also.
Also, because I complained to officer in charge. So, my lord, I will serve only upon the
on the advocate of the wife. Yes. Because incidentally, the officer in charge will be, if you direct him, he will comply. No difficulty on that.
My lord, get you. On Monday, under the
Monday, it will be taken
under the same heading.
Yes, yes, it will retain its position.
May I permit to, my lord, in this matter. In this matter, my lord.
You are appearing?
Yes, Mr. Arup Banerjee is appearing in this matter.
You are also there?
Yes, yes. But my lord, we are preparing the application, my lord, direction of the lordship. But due to illness of the client, my lord, could not afford.
What application you have to file?
That I could not say.
Substitution?
Yes, substitution.
You have already filed a substitution under Section 5?
Oh, no, one application direction of the lordship. Well, we have prepared, but
what application?
As per instruction of Mr. Arup Banerjee, my lord, taking for time 1 week.
My lord, I am appealing for the respondent.
No, the advocate, learned advocate for the respondents was to.
Yes, my lord, compliance.
You have
yeah, my lord.
Then you have filed a substitution application after
yes,
that.
Yes, but
my
due
lord,
to illness, my lord, and we could not affirm the application, my lord. Yep.
The application is already before us, substitution application.
Substitution.
Can 2 is an application for substitution?
For whom?
Who died? Who died?
Arup Banerjee.
Arup Banerjee is the advocate. Who died?
Yes. I because yes.
We'll appoint Mr. Bosumullik as the amicus curiae. He's having a good laugh at your expense. So you will, Mr. Bosumullik, come forward. You'll be appointed as an amicus curiae, and you will take
now
care.
He is rich man. Now he is rich man.
No, who has died? This
Respondent number 1. 1. Sayed.
Then unless you're not enjoying any interim order in any event because the substitution is pending. So you have not yet filed the substitution application. Let the matter go out of the list. We'll give you liberty to mention when you file that application. It is submitted by learned counsel for the appellants that the application for substitution of the deceased respondent number 1 has not yet been filed. Learned counsel for the respondents submits that in compliance of the direction of this
1 week time, my lord, only.
In compliance with the direction of this court, the particulars and date of death of the deceased respondent has already been handed over to the learned advocate for the appearance. 1 week you'll be able to do it. Yes. Very well. On the prayer of learned counsel for the appellants, let the matter stand adjourned till June 23, 2025. We are giving you 2 weeks. June 23, 2025, push up. The liberty is given to the appellants to mention the proposed application for substitution of the deceased respondent, if filed in the meantime, for inclusion in the list along with the other pending applications in the meantime. Whenever is
respondent number 1 is unmarried, my lord, issueless.
Yes. So
brother will get this.
No, brothers are on record already.
On record. Respondent number 2.
Then
number 2 is the brother.
As per my instruction, my
file a 1-page application asking for expunction of the name.
Recording of
1 week time, my lord.
Then 23rd na kore, June 23rd na kore, June 18. 1 week's time.
Yes,
returnable date is June 18.
Yes.
File a 1-page application, file it along with this and ask for expunction of the name. We could have done that orally if Mr. Banerjee was there.
Only recording of death.
Yes. Since you are also saying that, let us see, let them file an application.
I'm appearing for the appellant.
Yes.
And I have served the copies upon the respondent This affidavit of service.
They have received.
They have received.
Let us take up the application. Yes. Can P is the substitution application. We should take that up first, then the restoration. Acha, yes. What is the delay in filing this?
Delay of filing the appeal 121 days.
120. What is the reason given?
Reason was that lordship that initially the while the suit was dismissed, thereafter it was applied the certified copy. Certified copy was obtained sometimes after 4 months.
No, the delay in filing the substitution application.
Substitution application. Substitution application is
So there's a delay in filing the appeal also.
Also, there is section 5 also for appeal.
So you are a habitual defaulter, your client.
So it was a mistake.
First, let us hear about the substitution application. What is the reason for the delay?
This particular respondent number 1, he died sometimes in the month of 23, in the year 23, and it was not within our knowledge. We came to know the death intimation in the year 2025, in the first week of February. Thereafter, lordship, the matter was, while the matter was restoration application was filed, it was not came. Suddenly it was mentioned in the month of February, in the month of March.
No, the respondent number 1,
Yes,
who has died, is one of the Shebites of the DT.
No. Shebite of the DT filed the suit. And also
They are not Shebites.
No, they are assuming that.
So where have you set it up? All right. They are saying that it is a secular property.
Yes, Lord.
So respondent numbers 1A to D, they are the opposite parties here. Where have you mentioned the names of the heirs in your application? In Can 3?
This is the
Para 9, yes.
Para 9 and
in view of sufficient explanation for the delay in preparing this application having been furnished, comma, we take up Can 3 of 2025 and we allow Can 3 of 2025, comma, thereby directing the substitution of the heirs and legal representatives of the deceased respondent number 1, comma, as mentioned in paragraph number 9 of the application, comma, as respondents in the appeal upon setting aside abatement on condonation of delay in filing the application. Full stop. আচ্ছা এর সবকিছুর আগে একটু দিয়ে দিও affidavit of service filed to be kept on record despite service none appears for the respondents. তারপর যেটা বললাম no address to costs. আচ্ছা next let us take up this restoration application.
Can 2.
What is the reason? Restoration application filed in time?
Yes, that is within time.
What is the reason?
Reason was that when the day it was fixed for hearing, I was
very well. Since sufficient grounds have been explained for the absence of the appellant on the relevant date when the appeal was dismissed for default, comma, Can 2 of 2023 is allowed, comma, thereby recalling the order dated September 20, 2023 and restoring FAT 592 of 2018 along with the connected applications to their original file and number. No address to costs. You have served all these applications on the respondents, the affidavit of service, all the 3 applications. Well, yes, let us take up the section 5 now. What is the delay in filing the appeal?
That was the ground for obtaining the certified copy for the initial stage. Thereafter, in the year 2018, lordship, there was a seize work happened in connection with some departmental procedure, so that time the appeal was not able to file within the time. Thereafter, lordship,
this is from which court?
This is the city civil court. So thereafter, lordship,
hypertension, sleeplessness are these good grounds?
That is
all of us have it.
No, that
at least after hearing these sort of matters, we all get hypertension and sleeplessness.
Sometimes suffering from all type of ailments at that time.
They've incorporated everything. COVID has been left out.
COVID, thereafter the
But
COVID
then there was no COVID.
There was no COVID.
2018. Dental problems. So what sort of a section?
Actually, from the very first stage, the advocate on record who has conducted the suit, that from his record, the original documents and other relevant papers were not obtained by the appellant. So in that circumstances, we have also been deprived to get the proper remedy, and there was a lack of some timing for filing the appeal within that time.
Section 5 is really regular. Can 1 of 2018 within bracket old number can 8713 of 2018 is taken up for hearing, full stop. The explanation furnished by the appellant is in preferring the appeal late is the several elements of the Shebaid in charge of the appellant hyphen deity during the relevant period, comma, including hypertension, comma, prostate problems, sugar, sleeplessness, comma, knee injury, and other problems. Full stop. We also find from the abatements made in the condonation application that due to such health condition, due to such persistent ailments, comma, the said Shebaid could not regularly meet his learned advocate and affirm the memorandum of appeal in time. Full stop. Upon going through the abatements made in the application as well as the annexures to the application indicating the ailments of the said Shebaid during the relevant period, comma, we are satisfied that sufficient reasons has been shown for the delay in preferring the appeal. Full stop. Accordingly, can 1 of 2018 within bracket old number can 8713 of 2018 is allowed, thereby condoning the delay in preferring. It's still FAT.
FAT.
FAT number 592 of 2018. Full stop. The appeal is deemed to stand registered and admitted accordingly. Any other application?
No.
What is the appeal? No other application. What is the appeal against?
Appeal against the dismissal of the suit. That the
So we'll direct you to prepare paperbooks, the usual directions. The appellant shall put in requisites and postal costs for service of notice of the appeal on the respondents within. Have you got contact with your client now?
Yes, yes.
Within a week from date, full stop. The trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the arrival of the trial court records on the learned advocate for the appellant, who have liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. যদি না লিখে থাকি প্রথমে বলে দিও affidavit of service filed to be kept on record despite service none appears for the respondent. Thank you.
For the added respondent in this matter.
Yes.
My lord, there are 4 applications, but I find from the yesterday, my lord, I find from the order sheets, my lord,
Yes.
that on 19/8/2021 this matter was dismissed.
Appeal was dismissed.
Yes, my lord.
Yes, I filed a restoration. In the meantime, substitution application. My lord.
Those are all before us.
Yes.
Only 3 and 4 are appearing before us.
No, others application was
But
previously.
so far other applications is concerned, only, my lord, the copy.
Stay application is with you.
Stay application has been served upon me, but so far others, my lord, I have.
Please serve all the copies of the appeal.
Substitution application upon the receiver.
You also want copies of. Mr. Bosumallik will make photocopies and hand it over to you from his immense wealth.
Substitution application.
Whatever application is there, give copies to both of them, Mr. Nundi as well as Mr. Bosumallik. Come back on Monday.
এইটা দিয়েছো শুধু এই তো।
Please just sort out between yourselves whatever copy you have not got.
I have the restoration or recalling whatever.
Nothing.
Nothing I have.
Give copies of all the applications to them.
Yes.
And what about the other applications? Why only 3 were mentioned? 2 were mentioned, 3 and 4. এটা কি mentioning এসছে? Mentioning slip কোথায়? দেখুন।
Earlier 2056 of
4.
2008.
You had mentioned only can 4. সবকটা যা যা দেখবেন তো আর কোনো অ্যাপ্লিকেশন পেন্ডিং আছে কিনা সব 1 to 4 all are pending.
Yes.
1 to 4 দেখে নেবেন একবার পেন্ডিং আছে সব দিয়ে দেবেন। হ্যাঁ হ্যাঁ জানি করে আপনি করে দেবেন। The learned advocate for the appellant shall serve copies of all the applications on his counterparts appearing for respondent number 3A as well as the added respondent by tomorrow, full stop. The application shall be taken up for hearing, but you also have to serve on the other respondents.
They are not appearing.
No, restoration application, substitution application you have to serve in any event. Full stop. The learned advocate, the appellant shall also serve copies of the said applications on the non-appearing respondents and file an affidavit of service to that effect on the returnable date. Full stop. Let all the pending applications be listed together for hearing on June 23, 2025, when such affidavit of service shall be filed. We are giving you 1.5 weeks. When should you keep it? Tell us. Next week. June 23 na kore June 30th June. You get more time. 30th June, you have some problem. Yes, you have problem on the next Monday? No. So 23 goes, 30 goes. Next Monday is 7th July when the combined list will come up. Thale tumi ek kaj kore shall next be listed in the monthly list of July 2025. Mr. Nondi, please give all the names of whoever is appearing with you also.
I'm for the respondent, my lord.
Yes, Mr. Mukherjee.
My application.
What is Mr. Yes, Mr. Ghosh.
My lord, this application arises it's in a
Mr. Ghosh, you are all right. You look a bit dry and ruffled.
Lord, just as arguing the code number written just.
Code number?
8.
This is the result of that.
So long, Lord, so much.
Your hair will again come into place when we finish here. Yes, Mr. Mukherjee.
Yes, my lord.
Your application, what is the appeal against?
Yes, appeal. My senior friend has filed an appeal against the grant of probate. Probate by a testatrix, whereby the entire property has been given out for charitable purpose. The house property has been given to the University of Calcutta University for setting up of the libraries and also for some amount for looking after the maids who were all looking after. Now that probate is granted. They had huge properties, and now one of the property is a house property which is more than 100 years old, which is now locked up. The probate will envisage two persons as executors, one executrix, another executor. The person who took the probate expired already. So the second person has been substituted, which is now pursuing this matter.
The lady is surviving.
Lady has expired.
All right.
And the other person has stepped in, his brother. And now we need to manage this as properties. For that, the proper inventorying is required. My prayer is appoint any person from this honorable court in whose presence will open that house, because the keys are not handed over to us after the date of the original executrix.
What are they? They are
the family members who are opposing this grant.
Obviously, yes. The key is with them.
No, keys are not also with them.
Also with them.
That's under instructions, Mr. Ghosh. My learned
Key is
senior
with lying with whom?
It was supposed to be with the executrix who expired, but after her death, we did not get those keys. But in any case, the house
break open the padlock then.
We have to break open, but we want to do it in presence
Definitely,
of...
don't break open by yourself.
Yes. That's why we seek the assistance of Lordship that appoint some responsible person who in whose presence the house
For breaking open the padlock, it will be better to appoint an irresponsible person.
and the inventorying should be done of all the assets, because ultimately if the probate stands, then we have to
either way the property has to be accounted for.
And if this application is allowed, my learned friends' clients will not be prejudiced in any manner.
Mr. Ghosh, what do you say?
It is in the interest of the.
Kindly see my learned
We
friend.
can direct breaking open of the padlock one. Secondly, the keys can be, I mean, it was with the executrix, so it cannot be given to you at this stage.
No. Lord, your lordship kindly see in other probate application that
There is another probate application.
Yes, that has been refused by the learned trial court, and appeal is preferred.
That appeal was being
Preferred
heard
by
in the court.
Substitution, the respondent hearing. Lord, here.
No, the same will.
No, two wills.
Two wills.
Why?
Earlier will was the.
Which one
was?
Earlier will was not the.
By the
that
husband.
That is no, not husband.
Yes, Biren Roy.
No, Biren Roy's wife Meghmala Rai executed two wills. By one will, she bequeathed trusteeship. That is the ground on which the will was probate was revoked. Was not allowed. That is under challenge by Sukti Sanal, the executrix.
That was the earlier will.
Earlier will. In 2000.
So this is the later will. This will prevail in any event.
No, this is another property, other property.
Other property. So
But,
that's no relation.
both the properties are involved there.
So that has no connection with this.
No, yes. Because your lordship kindly see there was an inventory by the district judge and all articles have been taken into account and it was given to the official receiver state of West Bengal.
Why?
Lord, because by the said trust earlier will, the trusteeship was given to state of West Bengal.
By the testatrix.
By the testatrix.
But their probate was not granted.
Not granted, it is in appeal, it is pending.
But then how could it be given to the beneficiary?
No, not beneficiary. Nothing has been given now. It is still in the custody of the official trustee, the papers, and the door has been sealed.
No, not
and the inventory.
This property.
This property, 3 Sovereign Rai Road,
Sir, of course, you file an opposition to this.
Yes.
Bring everything on record.
And Lord,
this property is not part of that will.
But it has been.
We annex both the wills. We will not look into the documents. Just annex it to so that they can also have a reply. The annex whatever document, we have to look into both the wills.
Yes.
Lordship.
Which is very obvious.
Yes.
And the other documents Mr. Ghosh wants to cite, those will also be looked into.
Yes.
Since the present application is in the nature of one for appointing a special officer in presence of whom the respondent stroke petitioner seeks to have the house property which is the subject matter of the disputed will opened and the items lying therein being inventorized, comma, the appellant stroke opposite parties shall file an affidavit in opposition within a fortnight, Mr. Ghosh, or you have the documents.
Yes.
Within a fortnight from date, reply if any shall be filed within a week thereafter. The application shall next be listed for hearing on July 8, 2025.
Lord, make it 3 weeks because
3 weeks.
Yes.
Okay, within a fortnight যেটা বললাম affidavit in opposition টা within date দিয়ে
can do it in 1 week. All documents are.
Lord, there are some difficulties.
Within affidavit in opposition within July 2, reply within July 9. The application shall be listed for hearing on July 14, 2025. It is postponed by a week.
I'm obliged.
26 recorded with automatic government.
Lordship, I am praying for 2 weeks for time.
You have to serve copies. What about that affidavit of service? Unless you have, if you have to file that affidavit of service. Why 2 weeks time?
Lordship, my senior is not present at this moment.
No. What is the matter? You have to open the matter, ma'am.
No, sir. No,
An adjournment is sought on behalf of the petitioner without disclosing the ground for seeking such adjournment. First up, as a last chance to the appellant to move the application, move the matter, comma, let the same stand adjourned till June 23, 2025. First up, it is made clear that in the event the appellant remains unrepresented and or any adjournment is sought on the next occasion, ex parte orders may be passed in respect of the pending application. 23rd June, about 2 weeks.
I am appealing for the appellant.
Yes,
Lord.
Mr.
Lord, this is an suit has been dismissed under Order 7, Rule 11. I am the appellant. Lord. On the last occasion, your lordship will recall the appeal has been filed by plaintiff number 1, who is the company, and also by the 2 directors who are the guarantors.
Yes.
Plaintiff number 1, appellant number 1 has gone into liquidation and CIRP. So, my lord, on the first day, your lordship held that since we have also filed the suit in our individual capacity as guarantors, we will be entitled to proceed with the appeal.
Yes.
In place and stead of plaintiff number 1. Thereafter, notice was issued to the plaintiff number 1, represented by the RP now.
Yes, yes.
And my lord, they were given a chance to
Mr. Lakmani appeared for
yes, yes, to give a chance.
What
to
about him today?
I do not know, my lord. He's usually there.
Mr. Shin, give a notice to them because that is very important, vital
Yes,
here.
whether they would like to
Yes,
stay
only
as
that.
appellant or they would be
Only that.
transposed.
If he expresses whatever he has instruction on,
There is also, my lord, a Section 5 application. That can be.
nothing can be taken, Mr. Chen, you
Very well.
understand.
Very well, my lord.
Since the resolution professional is unrepresented today when the matter is called on for hearing, the learned advocate on record appearing for the appellants is requested to serve a notice indicating that the application shall be listed under the same heading on June 16, 2025, Monday.
Very well.
When a receipt in that regard shall be filed. First of it is made clear that in the event the resolution professional remains unrepresented on the next date, ex parte orders may be passed in the absence of the said party. We'll have to take a decision on that. Mr. Naik, you also personally informed Mr. Lakmani that
I'll inform Mr.
at least take instruction as to what is his instruction.
His stand.
His stand.
Yes, sir.
I'll try to find out from him.
You appear for me. Tag. কিছু ডিফল্ট করেছেন রাখছেন Oh, condemnation application. We find from our order dated May 6, 2025 that none of the parties were represented on the said date, on the basis of a report of the stamp reporter to the effect that the heirs of the defendant number 11 had been brought on record as respondent numbers 12 small a within bracket to 12 small c, but no application for leave to prefer appeal against the said respondent was taken out. We accordingly directed the appellant to file such an appropriate application within a fortnight from that date. Even today, when the matter is called on for hearing, none appears for the parties. Accordingly, we have no other option but to dismiss the appeal and the connected application for default. Hence, FAT 93 of 2020, Can 1 of 2021 which is an application for condonation of delay in preferring the appeal, is dismissed for default. Consequentially, FAT 93 of 2021 is dismissed as time barred. There will be no arrest to cost. Section 5, automatically out of time bar. Interest হারিয়ে ফেলেছে 21 এর অ্যাপিল হয়তো দেখবেন সব মারা গেছে একই ফাইল দিলেন না আচ্ছা হয়তো সেপারেট বিক্রি অথবা নিশ্চয়ই হয় কাউন্টার ক্লেম নয়তো প্যারালাল দুটো সুট হয়তো চলছিল। যা যা বললাম ওই সেম অর্ডার হবে। এফএটি 94 অফ না ইয়ে তোমার ক্যান 1 অফ 2021 ইজ ডিসমিস যেটা বলেছে এক্স্যাক্টলি এক হবে। Accordingly, FAT 94 of 2021 is dismissed as time barred. Which of consequentially can 2 of 2021 and can 3 of 2023 are also dismissed. No arrest to cost. বাকিটা একই থাকে। হয়তো একটা কাউন্টার ক্লেম ছিল একটা ইয়ে ছিল অথবা অ্যানালগাস সুট ছিল সেম পার্টিকুলার।
Item number 31.
Yes, how are you? You're appearing after a long time before.
Lord, I am the opposite party, my lord.
Yeah.
Lord, it's
You are for
one-
the sole respondent, right?
Yes,
Yes. So 1 day delay. So far delay concern, but basically calculation mistake. That is can 3.
It's a huge delay, but you have to explain that.
Can 3 will
Yes, what do you say to that delay?
my lord, only information which I have received.
Probably,
only-
my lord, he has been served with application 1, can 1 and can 2. Because 3, my lord, there was a caveat. When we went to serve it, my lord, we are told, my lord, that they have taken a change. That's why we have sent it by direct post.
My lord, the list of today's cause list shows a defective one, my lord.
Defective due to the delay.
Delay. Actually we filed.
Can 1 টা কোথায় এখানে আছে?
Can 1 is my lord,
আচ্ছা can 1 ও পড়তে।
stay.
Can 1 is sorry can 3 টা কোথায়?
Can 3.
And
Can 1 রয়েছে 2 রয়েছে
One
এখানে
day.
দেখতে পাচ্ছি।
Take a copy.
এর মধ্যে নাকি? এটা মেমো
Paragraph 6.
ওটা ওখানে ঢুকে আছে নাকি দেখুন তো। Can 3 তো এখানে দেখতে পাচ্ছি না কিন্তু লিস্টে অ্যাপিয়ার করছে।
আসেনি নাকি?
লিস্টে
Can 3 filed on
লিস্টে অ্যাপিয়ার করছে কাজে থাকবে আপনার দেখুন ভালো।
23/5.
Have you served can 1 on the respondent directly?
Can 1, can 2
And
on the learned advocate who lost the caveat. At that point of time, caveat was present.
Can 3 you have not served?
Can 3, I have served it directly only on yesterday. My learned friend has come. Can 3
Directly on the respondent?
Respondent, because my lord, the learned advocate who was there, he told to my learned advocate on record that my lord, he is no more. The brief has been taken.
Then you can give a copy to
Yes,
him.
that's exactly I was saying. That's what exactly I was saying.
So would you like to go through it right now or
Paragraph 6.
My lord, since I am appearing on instructions, my lord, I have told to appear and take adjournment, my lord, in this matter. My lord, if he's served with a
yes, in any event, once we allow this can 1, can 3, then we will have to take up the other 2. So let him come prepared. On Monday we'll keep it.
my lord.
On the prayer of the respondent, the matter be adjourned till June 16, 2025. You please just hand over another copy to your learned friend section.
I already have agreement. Given.
And
So for the other 2 applications.
No, other 2 you have already got your.
Yes, the earlier advocate on record we
Yes,
have.
Yes, we are the present advocate, my lord.
As many times they are not duty bound to serve you as many times as you change advocates.
Kindly, so.
You treat your learned friend, all your learned friends to individual cups of coffee and they'll hand over. There is a cost we are imposing on you. Order হয়ে গেছে রেখে দিন এটা থাক।
Only the formal affidavit of service.
আচ্ছা affidavit of service file today be kept on.
And they are appearing after.
Yes. Please ensure that they get all copies so that they.
I'm ওসব ছাড়ো একটা কপি দিয়ে দাও তো আবার কি আছে
1 copy each 1 2 and 3
হ্যাঁ 1 2 ওর নাম্বারটা নিয়ে নাও
You're appearing?
1 to 7 respondent as a respondent.
What is this scan for? Can 3?
Can 3 is an injunction application. A status quo order has been given on the last occasion.
Acha.
My lord,
What should you do? They're not appearing. They're enjoying an interim order.
yes, my lord, a status quo order is enjoying.
We'll adjourn it for the last time. If they don't appear, we'll vacate the order. We had passed a status quo order.
A status quo order.
Although the respondent numbers 1 to 7 is represented through their learned counsel, none appears for the appellant to move the application. As a last chance to the appellant to move the application, that is scan 3 of 2020, the matter is adjourned till June 16, 2025. It is made clear that in the event the appellant remains unrepresented on the next occasion, ex parte orders may be passed in the absence of the appellant.
Interim order vacation. Interim order may be vacated.
We are giving them a chance. If they don't appear on the next date, then we'll do that.
My Lord, I'm appearing on instructions on behalf of the appellant. My Lord, Mr. Arijit Bordhon is appearing in this matter due to personal difficulties. He could not attend court today. If my lords would be gracious.
You had asked for adjournment on the last occasion also. On 20th of May.
My Lord.
What is the difficulty? He's not in town.
No, my lord. There is some sort of a medical emergency. That is what I have been instructed, my lord.
That was the ground on the last occasion also.
My lord.
You come prepared in the matter. We cannot adjourn it forever.
Lord, just a day's accommodation, my lord.
Very good. If he did not pay, you would have prayed for adjournment. You are ready with the matter? On the prayer of the appellant, the matter is adjourned for the day.
Deeply obliged.
Both of your names. Minus the name of Mr. Bordhon and whoever is your senior.
Just my name, my lord.
Just your name and just her name. Yes.
Deeply obliged, my lord.
Lordship, in this matter, and for this, the applicant.
Yes. What is the application about?
Lordship, I'm challenging the preliminary decree.
Yes.
Which was passed on 31st July 2023, Lord.
Yes, we'll make this order absolutely the disposal of the appeal. Usual order, continue with the final degree proceedings, but no final degree shall be drawn up.
That order has been passed, Lordship.
That was passed till disposal of the application. We'll make it till disposal of the appeal. That is what you're saying. We'll dispose of the application.
Let the appeal be decided, my lord. This
appeal will be decided right now.
This is the all the proceedings are going to be completed. My lord, the only by virtue pending of this case, my lord, the commission has done.
No. We had directed the trial court to continue with the final degree proceedings.
Only draw up any final degree.
Yes.
But other proceedings will continue.
That was our order.
That is taking the advantages of that. All the proceedings are stopped.
That is undue advantage. You point out to the court below. This is plain English.
I've seen it. I've seen it.
We'll maintain that order. Hard learned counsel for the parties.
Fixing a date, or any other.
Fixing a date for what? The appeal has to be ready for hearing first.
Yes.
That's what I'm saying. Hard learned counsel for the parties. Full stop. The appeal has been preferred against a preliminary degree of partition. Full stop. Next para. We find upon perusal of the materials on record that a prima facie case for stay has been made out. As a prima facie case for hearing of the appeal on merits has been made out. Full stop. Accordingly, can 1 of 2024 is disposed of by observing that the trial court shall continue with the final degree proceedings, including commission work. We are including it. Including commission work, but no final decree shall be drawn up without prior leave of this court, till disposal of the appeal. Full stop. You are for the only respondent.
Only respondent.
In view of the appearance of the respondent through her learned advocate, service of notice of the appeal on the respondent is dispensed with. Full stop. The appellant shall put in due requisites for. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. The trial court shall retain skeletal records for the purpose of continuing with the final degree proceedings. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. প্রথমেই করে দিয়ে affidavits of service filed today be kept on record. Thank you.
Grateful, your lordship.
You filed the affidavits of service today?
Lordship.
Yes, তাহলে kept on record. Thanks.
Well, I am for the respondent number 2, 2, 4,
4,
5,
5 and 6.
Yes. And
You are
1
for-
AB.
And?
No, 1 AB and 2, 4, 5, 6.
Who remains?
My lord, other 7 to
You are appearing for whom?
7 to 18.
7 to 18.
7 to 18 appear করছে না।
There is no 1C.
1C.
Yes, Mr. Rai? You are for which of the appellants? What is the appeal against?
Partition suit dismissed. My lord, before that, my lord, your lordship find there is a defect because the degree was drawn in the name of a dead person, but subsequently it appears, my lord, the substitution was effected and amended plaint was filed, but that was not brought with the degree. That's why the memorandum of appeal was also filed in the name of the person who has died. Therefore, I filed two
Addition of parties.
Addition of party application has been filed because substitution cannot be effected because it is.
That is which can?
That is can
3.
Can 3 up to 25. What is your because the application করতে তারপরে
Can 3. আপনি can গুলো একটু বার করে দিন তো। What applications we are hearing today?
The first the addition of party
and what other application? Can
the
3 and-
injunction is there.
Number can 1.
Can 1.
What is can 2?
Can do the disposed of.
Disposed of. Can
Disposed.
disposed of or substitution. That was disposed.
Sheet একটু দেখুন তো।
number তো can 1
Can 1 আর 3 pending লিস্টে দেখাচ্ছে ওই দুটোই অ্যাপ্লিকেশন গুলো চাই
Can do service হয়নি but can do তো নামটা
না ওটা নামেরই ওটা within জোসেফ যে করে যেটা নিয়ে ক্যান 3 টা জোসেফ আমি কিছু বলিনি যদি
35 এ দেখছি এখানে can 1 of 2023 আর can 3 of 2025 দুটো রয়েছে
one of 2025 আছে
অ্যাডিশন অফ পার্টি তো একটা হবে দুটোই তো
3 of 2025
না না এটা তো একটা স্টে একটা ইনজাংশন দুটো আলাদা 3 of 2025 আলাদা
সাবস্টিটিউশন তো হয়ে গেছে উইথ দ্য পিরিয়ড অফ লিমিটেশন হয়ে গেছে
অ্যাডিশন অফ পার্টি
এটা ফাইল হচ্ছে 23rd মে May I hand over my copy?
no don't then it will never be the original will never come
No, it is filed in this.
let it be placed before us we'll take it up after the recess আপনি রিসেসে চেক করে রাখুন যা যা অ্যাপ্লিকেশন আছে সবকটা যেন লিস্টে থাকে অ্যাটলিস্ট Yes. Yes, Mr. Marshal. Yes.
My lord, sorry, I am
No, no,
telling
no,
apology.
No, no question. All these are Section 5 applications, Mr.
My
Marshal.
lord, all the there are section 5 applicants, similar case,
What is
similar order,
what is the approximate delay in,
delay is 148.
148 days, my lord, in the first case.
and in the others?
Others, my lord,
All.
All 148. What is the ground?
My lord, grounds, my lord, I have taken, my lord, there are the my lord, I have stated
Health condition of the learned advocates.
my lord, some of them.
What do you say?
Oh, it's,
Lord, I don't want to raise my voice against this, my lord. Your lordship knows very well better than me. The government filing the appeal after huge delay.
140.
The land acquired 12 years before.
No, that is different. But
That is divine, relating to merit, my lord.
yeah, allowing the
My lord.
I leave it to your lordship.
the very good. There are stay applications also.
Yes, lord, stay applications are there.
Acha, these are regarding the same process of acquisition.
Yes, same proceeding
Yes,
of
my lord, and
acquisition.
there are so many items are there where, my lord, three items are there, my lord, the petition, appellant died.
My lord, we will take it to.
No substitution was filed.
My lord, during the pendency of the appeal, my lord, the
No, if the appellant has died, then we cannot pass orders in the name of dead persons.
No, the respondent died.
Whoever died.
My lord,
Pass
in
orders.
respect of 3, my lord, we are not.
Which three? Which three? Tell us.
Lord, item number 16,
Yes.
item number 18, and item number 20.
My lord.
20. Very well.
16, 18, 20.
We will take steps, my lord, my learned friend will
Acha,
supply
12 থেকে 21. 148.
148 days.
না না ডিলে আলাদা আলাদা ডিলে সংখ্যাটা এক নয় 1 ওটা but the ground is same in all the applications. এই 16 18 and 20 বাদ দিয়ে বাকিগুলোর অর্ডার একটা কমন করে দিন. Since these appeals arise out of the same process of land acquisition, comma, the connected applications are taken up together for hearing, full stop. We find sufficient cause being made out. Now, upon hearing learned counsel for the parties, comma, we find sufficient cause for the delay in preferring the appeals having been made out, and accordingly allow can section 5 যেগুলো আছে সেগুলো হবে হ্যাঁ such and such প্রত্যেকটা নাম্বার আলাদা করে দিতে হবে comma thereby condoning the delay in preferring the above appeals. Which of the appeals are accordingly deemed to stand admitted, registered and admitted. Stay applications are also there. Still direct the grant stay subject to their depositing with the Registrar General. That will be in view of both questions of fact and law being involved in the appeals, comma, we find that a prima facie case for hearing the appeals on merit have been made out. So accordingly, we grant stay of operation of the impugned judgment and decree in all the above appeals, subject to the appellant depositing the decretal amount with the Registrar General of this court within 4 weeks. Within 4 weeks from date. Full stop. There shall be.
There are, my lord, 10, my lord, 6 weeks, my lord.
6 weeks, very well.
No
Date
problem.
in any event will take 6 weeks. Within 6 weeks from date. Full stop. There shall be unconditional stay as granted above till such period of 6 weeks. Full stop. In default of making such deposits, comma, the stay orders shall stand automatically vacated without further reference to the court. Full stop. In the event of such deposits being made, comma, the stay shall continue till the disposal of the respective appeals. Full stop. Such amounts, comma, as and when deposited, comma, shall be invested by the learned Registrar General with in fixed deposit, in short-term fixed deposits with nationalized banks. Push of the learned registrar general, comma, upon being approved by the learned advocates for the parties, comma, shall also furnish the particulars of such deposits as and when required. Push of next para, such deposits shall be subject to the outcome of the appeal. আর যেখানটা বললাম শর্ট টার্ম ফিক্সড ডিপোজিট না করে শর্ট টার্ম ইন্টারেস্ট বিয়ারিং অ্যাকাউন্টস স্ট্রোক ডিপোজিটস দিজ আর অ্যাবাউট দিজ অ্যাপিলস আচ্ছা আরেকটু অ্যাড করে দিন ক্যান সাচ অ্যান্ড সাচ ওই এগুলো হচ্ছে স্টে অ্যাপ্লিকেশন গুলো আর অলসো ডিসপোজড অফ ইন দ্য লাইট অফ দি অ্যাবভ অবজারভেশনস পুশ অফ দি অ্যাপেলেন্ট শ্যাল in view of the appearance of the respondent, you are appearing for the respondent in all the appeals. In view of the appearance of the respondents through their learned advocate, comma, service of notice of the appeals on the respondents is dispensed with, full stop. The trial court records shall be brought by special messenger at the cost of the appellant, comma, also to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the arrival of the trial court records on the learned advocate for the appellant in each of the cases. Full stop. Liberty to the parties to mention the appeals for analogous hearing as and when those are made ready for hearing. The affidavit of service filed today be kept on record. আচ্ছা এই 16, 18 আর 20টা আলাদা একটা অর্ডার করে দিন এই তিনটে it is submitted by learned counsel for the respondent that sole respondents or
Sole respondent.
that the respondent in each of the appeals have expired during pendency of the appeal. Full stop. On the prayer of learned counsel appearing for the appellant, comma, leave is granted to the appellant to take appropriate steps accordingly. Full stop. Liberty to the appellant to mention the matter, mention such applications for substitution, comma, as and when filed, comma, for inclusion in the list along with the other applications. Full stop. Let these matters go out of the list for the present with the above liberty.
এইগুলো দে আমাকে এয়ারফিট গুলো দে পার্টিকুলার
এটা একটু টাইম লাগবে ও তো মেনশন করেছিল একসঙ্গে মেনশন করেছে হ্যাঁ আন্ডারস্ট্যান্ডিং ডিরেকশন
একটু বলো জসেফ বলো
ইয়েস সেটা পাসওয়ার্ড হয়েছিল যেটা চলছিল সেটা
16, 18, 20 ওইগুলো
এভিডেন্স সার্ভিস ওটা তো 16, 18, 20 হয়ে যাবে ইয়েস যেটা চলছিল পার্থ হয়ে যাবে কল করুন মুখে বলুন
35 madam, appearing.
Lord, I'm led by Mr. Parthopratim Roy.
Yes, what is the matter about? We had started the matter before recess. We had indicated that it will be
Yes, my
taken.
lord. Two CAN applications. One is about addition of party, my lord. And another is stay application or injunction application.
Which is the application for addition of?
My lord.
Can 3.
Can 3, madam, can 3.
Yes.
These are the left out heirs of respondent number 1.
Yes, my lord.
We had granted liberty to the there has been a correction effected to the memorandum. We had granted liberty previously.
Yes. But there was a direction of your lordship's order, madam.
In what context did you direct? Let us see.
Parul, Momita.
Oh, substitution has already taken place in the court.
The copy was not given to me, only the copy of application for injunction has been given to me. Served upon my client.
Addition of party.
And then in that case, it has to be solved on the. I was so. T and 30.
You serve copy on you are for respondent number 72?
2, my lord. Respondent number 2.
Acha. No, respondent of 2 he is appearing.
No, well, I am for 1, 3, 4, 5, 6.
Lord, 2, I am representing
The last occasion in a slip it was written 2, 4, 5, 6. Please write it properly in the slip today.
Well, I'll clarify. 2 লিখে দিস না, 2 তো আমরা appear করছি না, 2 নয় তো? না, জজ সাহেব বলছেন
You are for 2. You are sure of that?
Kamal Kumar.
হ্যাঁ। Kamal Pal were not appearing.
Just check up because on the last occasion you had appeared for 2 also.
We are appearing for
Kamal Pal. Yes.
Then
we are Vakalatma. আচ্ছা
Vakalatma?
For 2.
হ্যাঁ
দিয়েছে তো।
আপনার Vakalatma
Vakalatma already filed in the department.
Very well, I'll clarify, because 2, 4, 5, 6 we are appearing, there is no dispute, in respect to 1.
2 there is dispute.
1A, B, 3, 4, 5, 6 there is no dispute. Only dispute in respect to 2, In that case, then I have to take, But even if my learned friend appears for 2, we don't have any problem.
We filed that in the department.
No, you have no problem, no difficulty on the which Vakalatma was filed first.
To be very honest,
filed.
To be very candid, I have.
You're carrying
is on
miscarriage. Not of justice, but of the Vakalatna. So you have to take steps for filing a proper Vakalatna.
These, all the 2, 4, 1 AB and 3, 4, 5, 6, their name is there. Except
Anyway, learned counsel appearing for the respondent number 2 submits that no copy of Can 3 of 2025 has been served upon him. Full stop. The appellant shall serve a copy of the said application on the learned advocate for the respondent number 2 during the course of the day. Full stop. Let the matter be taken up. Let the matter be listed tomorrow under the same heading. Listed tomorrow, but probably we'll take up appeals first. Give a copy today itself. Give it to him, Mr. Ghosh. You can clarify with your client, Mr. Chattu.
Yes, today only I'll just probably he visited it.
He visited both places at the same time.
Many brothers. That is the main.
Everybody is having a say.
Everybody is having.
No, you have a talk with Mr. Ghosh and just clarify between yourselves.
Yes, I'll.
Great.
Item number 36.
Yes.
My lord, I am appearing on behalf of the appellant.
Yes. Somebody appeared for the respondent number 1.
Yes.
Certain you added. Yes. Well, yes. Yes, what is the matter?
The matter, my lord, is granted the injunction not to encumber part with possession of the property
from what?
till the disposal of the application.
This arises from what?
The challenges, I have filed the suit that I in declaration that the company is a tenant and they will not take any step without due process of law. They have been evicted me. Thereafter, I have filed the suit not under section 6, but it will be treated as section 6 because there is a prayer of declaration. The court has granted the judgment entirely on the different.
What declaration?
The declaration that I am the lawful tenant.
Lawful tenant.
I am the lawful tenant.
Judge, why did the judge dismiss?
Yes, madam. I am coming. The learned judge has dismissed on the ground that the Lakshmi Narayan Kaushik died in the year 2021 and the 5 year have been passed, so I have no right.
And what has been passed?
5 year have been passed under section 2G. The learned judge has taken a plea that the 5 year have been passed, so I have no right. But I have taken a plea that Lakshmi Narayan Kaushik is not the tenant. The tenant is the firm. And when the court has passed the order that the Lakshmi Narayan Kaushik was the recorded tenant and the 5 year has been passed, so they have no right.
This is an arguable question.
One more thing.
Yes.
There is also a prayer that I have said that I am not in a position, but because they have dispossessed me. The court has held that the plaintiff number 1 and 2 will not be thrown from the suit premises without due process of law. Well, my case is that I am not in a position. The court says
the court meant thrown in.
Yes.
Not thrown out.
Yes.
You will not be thrown into the property without due process of law. Yes. So we'll ensure that does not happen because we'll continue this. We are directing to prepare paper books and you are for the only no.
Defendant, respondent number 1.
But the other has been served. The track report says the respondent has accepted.
But all of you contested together in the court below.
No, my lord, I am only appearing my instruction to appear respondent number 1 because now the property, my lord, running by the respondent number 2 and 3. Already eviction has been done. Already he was evicted from his house. There
Or for one.
I am 1.
And no
So
written.
you contested together by filing a written statement together in the court below.
That was true. What I have.
No written statement has been filed.
No.
The suit was decreed ex parte. No written statement has been filed, my lord.
Then you put in requisites for service on regarding the appeal.
Yes.
Application we are dismissing. Upon hearing learned counsel for the parties, we find that sufficient arguable questions have been made out for hearing of the appeal on merits. Full stop. Accordingly, can 1 of 2025 is allowed, thereby restraining the respondents and or their men and agents from by an order of injunction from transferring, alienating, encumbering, and or parting with possession in respect of the suit property, and or creating any third party interest in respect thereof in any manner till disposal of the appeal. Fullstop প্রথমেই একটা add করে দেবেন, affidavit of service filed to be kept on record. Fullstop despite service, none appears for the respondent numbers.
But they already evicted from the suit property.
2 and respondent numbers 2 and 3.
By way of suit file.
That is why we are granting injunction, restraining you from parting with possession. We are not asking, we are not protecting their possession. None appears for the respondent 2 and 3. যেটা বললাম complete হয়ে গেল. No address to costs. The appellants shall put in postal costs and requisites for service of notice of the appeal on the respondent numbers 2 and 3 within a week from date. Push of service of notice on the respondent number 1 is dispensed with in view of appearance of the said respondent through his learned advocate. Next para, the trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within a week. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
I am grateful, my lord. I am grateful.
My lord, 37, my lord, I appear for the appellant opposite party, my lord.
Appellant opposite party, it's a respondent's application.
Sorry, yes, my lord. There's a matrimonial suit, my lord, filed by my husband, which was decreed ex parte. My lord, pursuant to lordship's direction, my lord, the service has been effected. May we file the affidavit of service?
Yes, yes, please do.
No. It has been filed. My lord, can 2, if your lordships kindly take up, it is the application for condonation of delay.
No,
my lord, in the cost list, my lord, it shows there is a defect, but
that is the delay.
Yes, the delay has been application has been filed. Can 2.
Yes, yes, that will be shown till it is cured. What is the
Yes,
delay,
lord.
Mr. Bhattacharya?
Delays of 352 days, my lord.
Explanation?
From paragraph 8 at page 6, paragraph 8 onwards, my lord.
What is that? Took steps.
My lord,
No
what had
explanation
happened?
at all. Yes, no explanation at all.
No, paragraph 8 onwards, my lord.
Yes, took steps
Yes.
for obtaining certified copy.
Yes, because my lord, I was not aware that the decree has been passed. Subsequently, my lord, around September 24, I came to know, and then my lord, there was a decree passed. Then I instructed my learned advocate to apply for the certified copy. The
No,
certified
you had
copy was-
entered appearance. You had entered appearance in the suit.
Yes, I had entered appearance, my lord. I had filed an application for transfer under section 24 before the Honorable Circuit Bench at Jalpaiguri.
Yes.
What had happened, my lord, since the court was at Islampur, the Honorable Court was pleased to direct the application to be transferred to the civil revisional application to be transferred to the Honorable Principal Bench.
Huh.
It was transferred there, then subsequently renumbered, my lord, but the hearing could not take place. Now we had entered appearance and we had informed the learned court about the pendency of the civil revisional application. But thereafter, my lord, since there was no stay and no progress could be made, my lord, the suit was decreed, my lord. Subsequently,
should
my
have-
lord,
You should have taken information about the suit in the meantime. There's no
lord, I
explanation
should
why you
have.
didn't. There's no
No,
explanation.
No, that I did not, my lord. What is not there, my lord, I cannot write.
Have you remarried in the meantime?
Yes, Lordship, the court was reminding to the.
Have you remarried in the meantime?
Yes, Lordship.
So, when?
Lordship,
File an opposition to this will grant you liberty. Mr. Bhattacharya will direct them to file opposition against the Section 5 first.
Yes,
They have
Yes,
said,
Lordship.
they say they have remarried. If they have remarried,
Yes,
we
my lord.
take your explanation with a pinch of salt.
Yes, your lord.
On the prayer of learned counsel for the respondent husband, comma, the respondent is directed to file an affidavit in opposition to the Can 2 of 2024 within a fortnight from date. Full stop. Reply, if any, shall be filed within a week thereafter. The applications shall be listed for hearing on July 8, 2025 for hearing.
Grateful.
প্রথমে করে দিয়ে affidavit of service filed to be kept on. Thank you. Please come back. Let us see.
Yes, your lord.
Item number 38.
124 ফাইল করে বসে থাকবো তখন দেখবো না বিয়ে করে নিয়েছেন সেটা হচ্ছে মুশকিল বিয়ে না করলে অ্যালাউ করে দিত যখন জানতে পেরেছি বিয়ে করেছি তখন একটা অ্যাডভোকেট ফাইল Yes, 38. Yes,
In this matter, I am on behalf of the appellant, my lord.
right.
My lord,
Respondent number 15.
My lord, I am appearing on
Only 15. You are for 15. You are for
I'm for 6, my lord.
6, 11, 12, and 15. You have served on the rest.
yes, my lord. I have served everyone, my lord, but your lordship had instructed me to take the direction, to take the instruction from the client that who are not appearing in the lower court till date. So I have the instruction, my lord. This is the affidavit of service. If you can go through it, these are the.
I am appealing for 1, 2, 4, 5, and 8 and 9. 1, 2, 4, 5, 8, and 9.
It's a difficult calculation. Who are left out?
Yes, my lord.
3 is left out.
Respondent 3, 10, 13, 14.
6 is there. 7 nobody is appearing.
7 here, nobody is appearing.
7 nobody is appearing.
But
10
here 3, 10, 13, 14, they were not appearing in the lower court also.
Acha, 3, 10, 13, 14 will dispense with service.
Yes, my lord.
7 is the sticking point.
Okay.
Have you served on 7? Check
Yes,
that.
yes, my lord.
Yes means he has received. He or she has received.
Yes, I'm just checking, my lord.
Pick up.
No, no. No, it has come back.
With what endorsement?
It is given in the track of consignment.
Find
Page number 13.
13. Insufficient address. You have to serve again then.
This is the address I have, my lord.
What is the suit for? What was the suit for?
My lord, actually, this suit relates to the land scam which is operating in different areas. Different imposters and fraudulent people, they were selling the land in different innocent buyers. And here the appellant is the victim. How he is the victim? He had purchased the land from the bona fide seller or the vendor, but still he cannot take the possession over there, my lord. For that reason, my lord, the appellant had filed that title suit in the trial court, in the lower court, my
Seeking
lord.
declaration of your title.
Yes, my lord. Yes, my lord.
An injunction. You have got
Yeah,
possession.
yes, my lord. We had got the injunction, my lord. In page number 15, you can find out that there was also an injunction.
Right.
And but all of a sudden, my lord, due to the laches of the bench clerk, my lord, in page number 12, you can see that the learned judge had dismissed the case on non-compliances. Just due to the laches, due to the laches of the bench clerk.
Bench clerk or your clerk? Your advocate?
No, bench clerk. It is given over here. You can go through the order, my lord, page number 12. In the can 1.
Yes. Where do we find the latches of the bench clerk?
My lord, in the middle, record was not placed on 9/4/2024 as the bench clerk did not forward court diary and daily cause list from 18/3/2024 to 9/4/2024. So no step was taken by the parties on 9/4 in this suit. Therefore, as the parties to suit are not following the orders passed by this court, that the present suit being an TS 69 Ato BA is dismissed for non-compliance of this court, my lord. But this is a fit case, my lord. My appellant, despite of giving the full consideration of payment to the bona fide people, bona fide purchaser, cannot take the possession, my lord.
As the parties to the suit are not following the orders passed by. What sort of power?
Yes, my lord.
Mr. Mahato will set aside this.
Yes, my lord.
Sort of a. You also did not take any steps.
We have taken it.
Defendant number 11 and
Achha, with the court records that
We have always taken steps.
parties should have sought.
The entire order sheet should bring brought before your lordship. Otherwise, my lord, it was there, my lord, that they were not appearing because, my lord, they were enjoying the interim order. After that, my lord, they were not appearing, and my lord only.
But the
had
judgment itself is contradicted.
Yes, my lord.
I do understand, but
The court itself observes we cannot go beyond that.
Yes, my lord.
Prior to that, my lord, direction was there.
Yes.
If your lordships kindly come to third paragraph. Defendant's number 1, 2, 4, 5, 8, 9, and 6, 11, 12. Filed Hajira through learned rule. It is observed by the court that filed order number such and such. Next date was fixed for service return and deficit court fee by defendant number such. The said order not complied with by the defendant.
there was some.
But from 18/3 onwards, the bench clerk did not post it.
Yes, my lord.
My lord,
So therefore, 18/3 was the next date.
Date is required to be extended.
my lord, there was.
compliance after setting aside. Otherwise, my lord, unless the order is complied with, my lord, simply
No, the order has to be complied.
Yes.
That deficit court fee has to be put in.
have to take step, my lord.
Has to be done.
Yes.
But since from 18th of March, it was not posted, therefore it was not their fault.
Yes, that's true.
Practically, my lord, they have come up before this honorable court for speedy disposal
But
of the
my lord,
matter.
on the,
There was an order.
on
That
9th
is why.
No, but the suit has been dismissed.
Yeah,
has been
my lord,
dismissed.
by not
On-
that then, but after
has
1
been-
year of that.
Suit has been
My lord, in
dismissed on 9th of
2023,
September
Honorable Justice
2024.
Shapa Sarkar had passed the order.
Speedy disposal,
there.
that order was there, my lord.
Yes.
No, by
So
page
it is-
12, the suit itself is dismissed.
Yes.
Yes, my lord.
But
On
that is on
15th of
9/4/20.
September, Suit has been
Yes.
dismissed for non-compliance with the earlier date.
Earlier orders, not only for the bench clerks, my lord. Earlier orders was also.
That is the deficit court fee.
No, not only that, my lord. They were not appearing also. My lord,
Service return was, my lord, due.
due.
If another date was fixed, they did not appear. Other
Yes.
dates were fixed, subsequent dates were fixed. For that prior non-compliance means non-appearing.
Non-appearing.
It could not have been dismissed.
Yes, my lord.
That is.
Previously, somebody did not appear for that. How if I fix a date,
I do understand.
then how
my
can it
lord,
be?
I'm just
Peculiar
bringing-
sort of order.
Yes, my
Judge,
lord.
in 2023, there was direction for service return.
The appellant is suffering.
Those can be, these are curable defects, Mr.
Yes, that's
Yes, my
we
lord.
are submitting your lordship that time may be extended to take steps.
Yes, they have to. In default, that they will be again
Yes,
dismissed.
that's
But
Yes, my lord.
so order has to be set aside.
My-
Respondent number 7.
Set aside, my lord, they will
They
not be
can
able to take
take
steps.
steps.
Yes, my lord.
Exactly.
Yes.
Exactly. Nothing will happen. This will remain. But the defendant number 7, what about that? Is the sticking point. Defendant number 7 contested.
Number 7. Well, I think minor natural guardian misses. I
Oh,
think
achha.
that number.
Minor.
Minor,
7 minor.
Represented by natural guardian mother. I don't know. Contested in the school.
But if they contested from the same address, then it will be deemed that good service has been
Yes,
effected.
my lord.
We'll take up the appeal itself if all of you agree and dispose it off
Lordship.
and set aside this and extend the time for complying with all the directions of the trial court,
Yes, my
previous
lord.
directions.
Yes, my lord.
Within 4 weeks, we'll give you 4 weeks
Yes, my lord.
from the date when the trial court records have not come. So
Yes,
within
my
4
lord.
weeks
Mm.
from date.
Yes, my lord. Deeply obliged, my lord.
Thank you. You should be obliged to them also.
Yes.
Everybody of them is fair.
Yes.
But the prayer in this
Present application, it doesn't. That is.
We'll not look at the lock. We'll look at the stock and the barrel.
Well, because in this prayer is very.
We are not confident that it will be complied with by you again, ma'am,
That
in the court below.
Executing court will be passing or lordship will be passing an order to the executing
When the
court.
suit has been dismissed.
And the suit is
No
be
question of
dismissed.
execution proceeding.
Lordship may see the prayer. The executing.
Copy paste issue. Must be
Copy paste.
must be copy paste. Appoint a bailiff. What prayer have you made in the application?
My lord, actually,
You have directly asked to appoint a bailiff.
no, not a bailiff, a special officer if possible.
To do what?
Like if, some,
From the affidavits of service, we find that substantial service has been effected on all the respondents who appeared and contested the suit in the code below, comma, barring respondent number 7. Push up next para. However, comma, since respondent number 7 appeared from the address as mentioned in the cause title of the present memorandum of appeal as well as connected application, comma, we deem that proper service has been substantially effected on the said respondent as well, comma, since service was sought to be effected at the self-same address. Full stop. On consent of the parties who are present before this court, comma, we take up the appeal along with the application together for hearing in view of the very short conspectus of the appeal. Full stop. By the impugned judgment and decree, comma, the learned trial judge dismissed the suit for non-compliance of the court orders. Full stop. It is pointed out by learned counsel for the appellant that from the impugned judgment itself, comma, it is evident that due to the fault of the bench clerk of the trial court, comma, the court diary and the daily cause list was not posted with the proper dates from March 18, 2024 till April 9, 2024, and accordingly no step could be taken during this period. However, comma, learned counsel appearing for the respondents point out that even apart from the said period, comma, there were several previous directions, comma, including deposit of deficit court fees, which were not complied with by the plaintiff stroke appellant, comma, for which the suit was dismissed. Next para, we find that the learned trial judge proceeded on a technical approach by dismissing the suit itself on the grounds of curable defects. Next para, accordingly, comma, for the ends of justice, comma, the learned trial judge ought to have granted further opportunity to the plaintiff stroke appellant to comply with the directions of the trial court. Next para, accordingly, comma, upon hearing learned counsel for the parties, FAT 400 of 2024 is allowed, comma, thereby setting aside the impugned judgment and decree dated September 9, 2024, passed by the learned civil judge, Junior Division, Second Court, Sodor, comma, District, Paschim Medinipur, in title suit number 69 of 2018, and remand the suit to the trial court for a fresh hearing, subject, comma, of course, comma, to the plaintiff stroke appellant complying with the previous directions of the trial court, which were given before the passing of the impugned judgment and decree. Full stop. In the event the plaintiff stroke appellant complies in the event the plaintiff appellant would be permitted by the learned trial court and the concerned department of the said court to comply with the previous directives on the strength of the server copy of this judgment and order, without insisting upon prior production of a certified copy thereof. Next para, subject to the plaintiff appellant complying with all the previous directions of the learned trial court within a period of 4 weeks from date, comma, the suit will be taken up for hearing on merits and decided in accordance with law by the learned trial judge. However, comma, in default of compliance with all the previous directions of the learned trial judge within the above stipulated period by the plaintiff stroke appellant, comma, it will be open to the learned trial judge to dismiss the suit afresh for non-compliance of the orders of the said court. Can 1 of 2025 is disposed of accordingly as well. There will be no arrest to costs.
Deeply obliged, my lord.
Report of the stamp reporter, because
Here also there are defects.
Valuation is at 1500.
There is
In the
also a defect.
application, it is stated valuation 1500.
I don't know, plaintiff.
Plaintiff
We don't
copy?
have a copy of the plaintiff.
1500.
Yeah.
Application mallet is application valued at page 3.
The plaint has been annexed. Let us see the plaint.
Plaint has not been annexed, my lord.
Report.
No, this is probate application.
No. Suit for declaration.
Then this court does not have jurisdiction. Plaint is not annexed.
Plaint is not annexed.
Where is the plaint?
Not here is the plain, my lord.
Valuation কি আছে দেখো?
ফালতু খাটলো কত
100. The suit for declaration
I
means
would add
it
rupees
should be
100.
100.
The second civil judge, junior division, second court.
Yes, right.
Yes.
You do not strike me. Then you don't have jurisdiction.
My lord, here the valuation of the property is more than 32 lakhs, my lord.
Your suit, we go by the suit valuation. If the suit
He was misleaded in the lower court, my lord.
you are also misled by the
No, he was
you in fact.
He was misleaded by the
See,
lower court.
if the valuation of the suit is 100, Mr. Mahato and all your learned friends are right, you don't have jurisdiction.
Suit for declaration means.
So we dismiss the appeal as not maintainable before this court. We go before the district court.
Discharge her.
We go by your valuation of the suit.
Yes, my lord.
They have to come back and second appeal if it is
You
not
treat our
allowed in the
air court to a cup of coffee for taking so much time, taking a long dictation. At the outset, comma, it is affidavit of service filed to be kept on record. Full stop. At the outset, comma, it is pointed out by learned counsel for the at the outset, kora deben na. Mithe kotha. It is pointed out by learned counsel for the respondents that this court does not have pecuniary jurisdiction to take up the appeal since the suit has been valued as per the plaint, comma, at rupees 100. Full stop. We agree with such contention and hold that this court does not have pecuniary jurisdiction to entertain an appeal against the impugned judgment and degree passed by the learned civil judge, junior division.
second I think under second type.
কোন কোর্ট ওই যেটা বললাম যেটা একটু আগে সেটা ওই ওটা
Junior division second court.
yes full stop. Accordingly, FAT 400 of 2024 and the connected application bearing can 1 of 2025 are dismissed due to dismissed as not maintainable due to lack of pecuniary jurisdiction, with liberty to the appellant to prefer an appropriate appeal before the court having pecuniary jurisdiction to entertain such appeal. Full stop. The period spent during pendency of the present appeal may be considered by the learned appellate court, comma, if the appeal is presented within a reasonable period from date, comma, for the purpose of considering as to whether the same falls within the purview of Section 14 of the Limitation Act 1963. No rest to cost.
My lord, certified copy of the order.
Right. Leave is granted to the learned advocate on record for the appellant to take back the certified copies of the judgment and decree of the court below of the trial court upon furnishing photocopies of the same for the records.
Item number 39.
Yes.
In this matter, my lord, I am appearing for the
right.
petitioner, my lord. Here is the affidavit of service. Last occasion, your lordship.
Yes.
It is an my lord, case of Employees State Insurance Act. My lord, the question involved in this case.
State Insurance Act আছে ESI Act একবার আনিয়েছিলেন নাকি দেখুন
May I hand up my lord?
But there will be 2 copies required. So let us on the last occasion you had argued on this and we had probably fetched copies. Very short point. That's why we directed you to serve the memo as well as you have served. They are not appearing.
They are not appearing. My lord, this is the whole difficulties, my lord. This is the whole difficulties. My lord, thing is that
ESI Corporation is not appearing.
My lord, yes, in the trial court they have appeared. My lord, the thing remains, my lord, that I am the headmistress. My lord, I have 30 employees, including teacher and group D.
So, of course, the difficulties we intend to hear out the appeal along with the application in their absence.
That is true, my lord. If your lordship, I shall again, sir.
We'll record this. This time we'll record that the appeal will be all the relevant documents have been annexed to your application.
Yes.
All are annexed. Did you grant any stay of operation?
No, I am 17th is the last occasion. The learned judge, my lord, is not inclined to grant any time. That's why 17th is the date is fixed. Lord, your lordship kindly state for the time being.
17th is fixed for what?
For hearing of the matter.
Oh, you have come up against injunction refusal?
Yes, yes, yes.
You are the plaintiff there.
Yes. But for limited period, your lordship.
But Mr. Ghosh, you are Mr. Ghosh.
Yes, yes.
Mr. Ghosh, if the suit is decided in the meantime, then what is the difficulty? This is an injunction appeal, so why should it stay the suit?
Lord, unless we deposit the 25% of the amount, Lord, interim order granted on the basis of 25% of the claim amount has to be deposited. Lord, the difficulty is, Lord, I am not against the employee who is getting this. But thing is, the headmistress, Lord, the 30 heads, Lord, they are the appointing authority, headmistress, principal employer. But so far as the two para teachers, they are not. The appointing authority is the headmistress. It is the district project officer, my lord, who appoints them on a conciliated pay of rupees 13,000. Lord, they are not specifying the name in their notice.
What sort of an injunction did you ask?
I am paying stay for the status quo as on today.
No. I mean, what is the injunction prayer made by you, which has been refused?
Lord, your lordship.
It was an ad interim refusal.
My lord.
At the ad interim stage.
Yes, my lord.
Oh no. No, injunction was allowed.
Yes, my lord, injunction upon payment of 25% of the claim amount.
No, it was recorded that petition under section 75(2)(b). What is that provision, 75(2)(b)?
My lord, if your lordship can file an application before the ASI court. Matters to be decided by the Employees Insurance Court, at page 45 of my book.
75(2)(b), yes. No matter which is in dispute between a principal employer and the shall be raised. %50% was reduced to 25%.
25% I have to deposit. Then who will deposit? I have no fund. I am not the employer of that too, that they are not specifying. That para teachers. That para teachers, I am not the appointing authority, principal employer. Para teachers, district project officer under the Sarvashik Commission.
Affidavit of service filed to be kept on record. Despite service, none appears for the respondents. Next para. Accordingly, the application is taken up for hearing ex parte. By the impugned order, the injunction application of the appellant was allowed. However, the appellant was directed to deposit 25% of the last claimed amount to this court by virtue of a demand draft on any nationalized bank. Next para. Learned counsel appearing for the appellant raises the question as to whether the appellant, being the headmistress, is the principal employer as contemplated in section 75 within bracket 2 capital B of the Employees State Insurance Act, 1948, and as such, the scope and effect of section 1 within bracket 4 of the said act in the said context. Since a sufficiently arguable question has been raised, we had already admitted the appeal. We had also directed a copy of the memorandum as well as the application to be served on the respondents with the underlying intention that the appeal and the application could be taken up for hearing together. However, since the respondents choose not to appear despite service, we take up Can 1 of 2024 for hearing, full stop, since a sufficiently strong prima facie case has been made out, comma, can 1 of 2024 is allowed, comma, thereby staying the operation of the impugned order dated January 19, 2024 to the limited extent that the appellant was directed to deposit 25% of the last claimed amount in the said court till disposal of the appeal. First up, it is made clear that the order of injunction granted in favor of the appellant is not touched by this order and shall continue to operate in the court below. First up, next para. We further now we also stay all further proceedings in tender case number 91 of 2023 pending in the Employees Insurance Court, comma, West Bengal, Kolkata till disposal of the appeal. First up, the appellant shall put in due requisite postal costs and requisites for service of notice of the appeal on the respondents within a week from First up, the trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. First up, liberty to the parties to mention the appeal for inclusion in the list as and when the appeal is ready for hearing.
I'm grateful to your lordship.
Thank you very much. We have since you have stayed that portion of the order whereby you are directed to deposit
25%.
25%. If the suit was permitted to be proceeded, then it would tantamount to allowing the appeal in your favor. Because then the suit would be disposed of without that 25%. That's why you have stayed both. Your suit and that 25%.
I'm grateful to your lordship.
Item number 40.
Acha, 1 minute. আগেরটা ইয়ে করে দাও. Will not stay interlocutions. Otherwise, you won't be able to obtain an extension of that order. It is made clear that the above stay shall not operate in respect of interlocutory applications which may be filed in respect of the suit, but shall only pertain to the final hearing of the suit.
The 25% you have lordship.
That we have stayed. That remains. But the stay regarding all further proceedings will operate only in respect of the final hearing of the suit, not the interlocutory applications, so that you can file interlocutory applications.
Item number 40.
Yes, Mr. Banerjee.
My lord, there was a direction for filing supplementary affidavit. I have filed. These are my affidavit of service, but however, other side is appearing.
What is the matter about Mr. Banerjee? Just remind us.
Lordship, it is a injunction application which was allowed.
Mr. You are appearing for all the respondents.
Lord, I am for the attentive respondents.
Very well.
Respondent number 1 and 2.
The two was, Lordship has also observed that the pro forma defendant
dispense with all. Yes.
So, Lordship, this is, they have claimed that they are the tenant in portion of a building and for which they have obtained an injunction on the allegation that I, being the one of the landowner, is trying to dispossess them without due process. So, while that was been allowed, they have mainly relied on two documents, that is the rent receipt and certificate of enlistment. Lordship, what I found is the rent receipt cannot be pertaining to that premises because Lordship has also recorded in the last order that the itself their averment in the plaint as well as the injunction that this is the quantum. So 50% of that will not admittedly this. Now, Lordship, by way of a supplementary affidavit, I have brought few documents before your Lordship that indeed they are tenant, but not in premises, same premises, but not in respect of the ground floor. So they have their enlistment certificate, they have their rent receipt in respect of the first floor. This was a particular portion from the
suit property is the ground floor.
Suit property is the ground floor shop. there are many. So he is also having a proper tenancy in respect of a first floor. So he used all those documents for obtaining injunction here. This is the thing. And one the thing is that injunction which they obtained, if your lordship looks into their injunction application, what is the prayer? If your lordship kindly takes the injunction application once. The injunction for permanent injunction, restraining, that's at page 24 of the.
We are there.
An order for permanent injunction restraining the defendant, main agent, servant from interfering with disturbing the peaceful possession of the suit premises, more fully described in the schedule below, and also restrain the defendant number one, such and such, disposing from this.
Cannot be permanent injunction, must be temporary injunction. This is the injunction application.
The degree of permanent injunction.
This is the injunction application.
I know, but then lordship kindly turn
full portion, yes.
Now kindly come to page 20, para 5.
So we'll restrain only your antisocial elements from dispersing them. Your social elements can very well do that. They're specifically prayed for injunction that your antisocial elements cannot disperse them. So you send your social elements and do that. There's no bar.
Taste is
Yes,
very, in present day situation, taste is very difficult.
I have filed a suit for declaration and for injunction. In the said suit in support of
Yes, obviously,
yes. I have filed my rent receipt, my electric bill, my rent receipt.
No, let Mr. Banerjee place the discrepancies in those rates.
Now, lordship kindly turn to page 27.
27, yes.
Para 5 and then page 27.
Para 5 of this application or?
This application, lordship. Para 5, page 20, injunction application. He said that defendant number one is claiming himself that he is the owner in respect of the undivided 50% share of this, without showing any document and paper, without intimating this by letter of adjournment, such and such. Now, lordship, kindly see paragraph 2, page 90. That his strength of the injunction, lordship. The plaintiff are the tenant in respect of the said shop under pro forma defendant number 224, under pro forma defendant, who are the landlords having undivided 50% share of the rent in respect of the said shop, such and such, of the pro forma respondent 2, and 50% in respect of the said shop, such and such 3 and 4. The pro forma respondent lastly issued the rent receipt, 50% of this, subject to written this, and the month of this, according to English calendar this, issued another separate rent receipt in respect of undivided 50% share, which is 1500 per month according to the English calendar. So, lordship, there is a either. Now, lordship, kindly turn to page 27. If your lordship kindly turn to page 27 at the very bottom, first is 1100 is the enter rent. Enter rent is 1100, 50% का आधा 550. एकदम नीचे the last sentence is कृपया इस bill का payment सिर्फ AC payment check से ही करें. Sir, which is not has been done by them. This is, they rendered it by cash according to them.
And this is self-defeating because it's a rent receipt itself. By itself, this is a rent receipt.
How far we will believe this, lordship? Kindly turn to the next.
That's a regular. I mean,
no, lordship, kindly turn to the next one. 9-9. And this all are very adjacent to that period, lordship. October, November 2020. Yes. Lordship has got it?
Yes, yes.
So then again 1100. So, lordship, now he has given this.
This is 1100 into 3 or something.
Yes, yes. Now, lordship, kindly see 2090, page 30. Pushpa Devi Jhawar signed it, lordship.
Yes.
Now, lordship, kindly turn to my supplementary evidence.
This Pushpa Devi Jhawar and all, they are the they are the pro forma respondents 2 to 4.
Now, lordship, kindly turn to page 31. Kindly see that 1500 which he said.
Yes.
S. Jhawar. S. Jhawar is Shanti Devi.
Ganga Prasad Jhawar and Shanti Devi.
Shanti Devi. Lordship, kindly now come to my supplementary affidavit, page 15. Tanti Devi Varghese died in the year 2007. Now kindly turn to my, yes, my lord, that one. Lordship, kindly see date of the death. Now, Lordship, kindly turn to,
Oh, it has been signed by S. Jawar in 2021.
yes. And not only that, Lordship, 31, 32, 33, 34, it goes on, Lordship. Till 39. Lordship has got it. Now, Lordship, kindly turn to page 40. They have said that they have a enlistment certificate. These are the two strengths, his rent bill and this. Lordship, kindly come to enlistment certificate. The date of the without fees is such and such, so 2023, 22-23. Lordship has got. Now, Lordship, kindly turn to my page 18 of my supplementary. Lordship has got.
Yes, 18.
Lordship, then Lordship will find on the same premises Shavar Mangala and Company.
Sarva Mangala.
Sarva Mangala and Company.
Yes, not Shawarma.
Yes. And now kindly see who are the proprietors.
Some others.
Nee, Vishal Varga and Sham Prasad Varghese.
They are?
No, they are not here.
So they are not the parties to the suit.
No. Vishal Varga is there. Sham is not. So, Lordship, what this Vishal gentleman has done is, he has taken all advantage of his first floor. Now, Lordship, this Lordship will find this Vishal is, Lordship will see ward number 23, P18, ground floor. Lordship is getting this in 2020. So, Lordship, here parties were different. Now, Lordship, kindly turn to.
It's the ground floor of the same premises.
Yes, yes, yes. They have a separate shop, Lordship. Now, Lordship, kindly turn to the electricity bill, which is at page 16.
Yes.
Now, Lordship, the electricity bill will clearly shows Vishal Varga was there in a separate room.
All these documents were placed in the court below.
Lordship,
this will require a mini trial then, which is deprecated by the courts. At this stage, why should you do that?
Then Lordship, kindly see whether to
even
get
if you have a good
injunction.
case.
No, Lordship, to get an injunction, someone will take a possession illegally and then he will.
You had filed a written objection there, but you did not take these documents.
Lordship can now.
Then
yes. No.
Lordship, what under 27 you appreciate, but in an injunction, in connection with an injunction,
I understand.
Limited scope.
Now, Lordship, now we will go back. How he has come to the trial court has come to a conclusion. How the
There are arguable questions raised. These are arguable questions you have to prove on evidence. They also have to prove, we also have to prove all these documents. These are only annexes to the supplementary affidavit.
This is.
Let there be a trial on this.
Lordship, but I am only saying that first. Someone to enjoy a protection from a court, someone has to come unblemished as regard to his first possession. And thereafter, there might be a cloud on it. So, Lordship, if I do not look into my document at all, death, we can always look into. Apart from the death, I am not looking anything else.
Enlistment is there.
No, Lordship, that's what I'm saying. Whatever he has given, I am,
yes,
in my supplementary affidavit, only one factor I am taking into account. Death. So, death is on record, whether we put it on record or not put it on record. So, Lordship, then all the subsequent his documents are under cloud. That is his rent receipt he has to show. So, Lordship, he has to.
But in the absence of an evidence that his tenancy was terminated or he was evicted, once he shows previous rent receipts,
Lordship, no rent receipt, no 50% rent receipt. all his, what is his averment?
His
lordship?
Hindi receipts are there.
No, lordship, this Hindi receipts are there is the 50%. So to corroborate that Hindi receipt, he has to have that English receipt also for the same period. And now the same period, lordship, kindly see.
Aren't these receipts sufficient?
Lordship,
page 27,
to
28,
to understand someone's intention, he has to come up for 1 month at least that this is my Hindi receipt and this is my English receipt.
No, why should there be two receipts?
Because to complete the payment for 1 month, 50% from one man, 50% from another man.
Yes.
So he, for at least for 1 month, he has to come with a receipt, one Hindi, one English, right, lordship? And then that English has to be signed by a alive person.
Not a single receipt
But
by the
not
other.
a single receipt has been annexed, which is prior to 2007. So the entire rent receipt which he has annexed is under doubt. Now, if someone has entered into possession, whatever he has given is say on this. Now, lordship, kindly see, apart from the rent, if your lordship kindly comes to whether the court was aware of the death on. Now, this has to be a factor.
Did you bring it to the notice?
Yes. I said that this gentleman is no more alive. So whatever document he says, it will put to trial if the documents are prior to 2007. But if the document entirety in his file is of 2000 after 2007, then the equity should not be exercised against him. Now, lordship, kindly turn to the first order, which is at page 47. Lordship, kindly come.
We don't have the copy of it.
I have served it. No, amata now. Dekho.
Only half page.
Dekho. Mara jawata.
47.
Yes, page 47 is the injunction when was granted.
Yes.
Now, lordship, kindly see the document which the prima facie court relied upon. May I read?
This was the identity injunction.
Identity which is then
finalized.
Lordship, may I read the second paragraph? The point, consider whether there should be an identity injunction in the case. It is connected by the plaintiff, contended by the plaintiff petitioner, that the plaintiff petitioner are the joint tenant in respect of the suit premises. I pause here for a moment, lordship. If it is a joint tenant, then lordship, kindly turn to the rent receipt which have been annexed herewith.
That's why 50% probably.
No, joint tenant means the tenant name both should be there.
Yes.
So now kindly see whether that tenant name is there or not. Plaintiff number 1 and 2. Even in English or in Hindi. Lordship, Akash Varghese evam Vishal Varga. So lordship, Hindi in lordship is getting 2. And in English, if your lordship kindly turn into the next one. In English, lordship will not find. Lordship has got. So in the English portion, whether it is alive, dead, separate issue, but that name is not lordship is getting.
Rajkumar, Suresh Kumar, Subhash Kumar.
I have shown that they have other shop. I have shown from the document of enlistment. So I'm not relying on that right now. I'm only saying today the English receipt which they have annexed do not contain their name. So they have somehow managed, or they have got the document of 2019 of the Hindi version. So 50% receipt. Good, bad, indifferent. Now, lordship, kindly turn to again the impugned order. Ad interim order turned into impugned order. Thereafter, called the suit premises under the pro forma respondent number 2 to 4, who are the landlord having 50% share of the rent of the said premises, of the pro forma respondent number 2 and 50% rent of the said shop of the premises number 3 and 4. Learned advocate draws attention to the rent receipt issued by the pro forma number 2, 3 and 4. I pause here for a moment. So, court has considered their complete rent receipt from both the two sides. And prima facie, lordship, I found the names are not. it is further contended by the plaintiff petitioner that the plaintiff petitioner having carrying on business under the name and style Sri Salasar Balaji Garment. I pause here for a moment, Lordship. Kindly see that say English is in name of some other one. At the said room under the trade license issued by the corporate. The party have peacefully enjoyed the said room and having carrying on business without disturbance and hindrance. Landed advocate draws to the professional tax, electricity bill, and the trade license. So these are the prima facie document he has relied upon. It is contended that the defendant number 1 is claiming himself that he is the owner in respect of the 50% pay of such and such, without showing any document and paper and without intimating the plaintiff either by a letter of attornment or otherwise. The learned advocate submits that although the defendant number 1 has not furnished any document to the plaintiff regarding ownership, not issued any letter of
You did
attornment.
not file any written objection to the injunction application?
But they have filed an application under Order 13 Rule 4 that was rejected.
Kindly come to
Against that they have come.
Yes.
No, Madam, they have come against, they have not preferred two separate appeals, they have preferred only one appeal.
Kindly
My
come to
application
page
for injunction has been allowed. So they are subject to correction, they ought to have preferred two appeals.
So that 39 for rejection, yes, merges in the injunction.
Lordship, page 48 is my opposition.
But
I will take your Lordship.
You have filed an objection.
Yes, page 48. Order 48 in the opposition against the application and the
Injunction application.
This is my affidavit in opposition to other.
No. This is their affidavit to your order 39.
Lordship,
Where is your objection to the injunction application? You have not filed any.
No, I have not filed before your Lordship. All right, we have not filed.
What for that?
Not filed, Lordship. What we have.
Injunction application then stands uncontroverted. 39.4 is on a different footing, suppression.
Even for obtaining for a ex party, he has to prove his some locus
So
standi.
Banerjee, difficulty arises as Mr. They pointed out, then you have made one challenge, preferred one challenge. If you have challenged the injunction application, you are in a double, whether should you use whammy? Because if you challenge the injunction order by this appeal, then there is no written objection, non-traverse. And if you have challenged the order 39 rule for rejection, then in any event they get that injunction.
In an injunction, he will not get order 8.
That remains. There is no challenge to that then. And it was not treated as an objection. Then
these are some
arguable questions, but yes, definitely arguable questions, Mr. Banerjee.
Now, Lordship, let me take another 5 minutes of time. So, Lordship, he has directed. So this, then what is the contention? It is contained that the defendant number has been constantly disturbing the peaceful possession of the said suit premises, directed the plaintiff to vacate without cogent reasons, such as upon perusing the petition and upon learned advocate for the petitioner, considering the material on record, balance of convenience in view, hence the defendant number 1 is restrained by order from disturbing the peaceful possession of the plaintiff in the suit premises and disposing them from the suit premises, except by due process. Now, Lordship, kindly turn to Now, Lordship, kindly turn to page 49. His objection. Whatever he said is absolutely correct. Let's proceed on that. Lordship, kindly see page 49. I say that I have read and understood the meaning and purport of the pertinent such and such, modified addendum such and such in favor of plaintiff such and such. The plaintiff number 1 in his application alleged that one Hari Prasad is the original monthly tenant in respect of the premises such and such, and I have inducted this as a subtenant under such and such. When the issue a notice to eviction such and such, and the defendant number such and such is the counterblast to this ejectment notice such and such. No relation such and such, such and such. Then the plaintiffs are the stranger and such and such. They demarcated such and such, but the case is absolutely otherwise, which the plaintiff category described in the plaint, and plaint neither made by the false statement, no misreading this quote unquote. So neither maintainable in law and such and such and such. So, Lordship, I placed my case, and then Lordship kindly turn to the impugned order. Now, Lordship kindly looks into the impugned order. Now, Lordship will find in the impugned order, মেমোটা কোথায় গেল? মেমোটা মেমোটা Lordship, মেমোটা কোথায়? Lordship, I must submit before your Lordship that in the court below, in the record Lordship will find, there was an order 7 rule 11 application was also filed, and there it was a specific statement made that Shanti Devi died on 2000.
What happened to that? That is still pending.
That is.
Have you filed a written statement?
That is.
Have you filed a written statement? That last chance was given by this impugn order also.
Yes, Lordship.
Have you?
That I have to take instruction from the.
That means you have not filed. If you had filed, you'd have instruction.
No, it's not like that. As it is. I came very late in this matter. So. Injunction to paper. Now, Lordship, what I'm saying is, now if we read the order, Lordship will see from the impugned order. Last impugned order. If your Lordship kindly see, memo of appeal, it impugned order. If your Lordship kindly see, the today is fixed for such and such, both the petition are taken up, heard this, while order the court such and such, disturbing peaceful possession such and such, has verbally stated that the performer dismissed Shanti Devi had added, but he did not file any written application or document to that effect, and the defendant. Lordship has got it. So I said that statement. Plaintiff are directed to make an inquiry whether that plaintiff is alive or not. So plaintiff has given a direction to that. The court of the defendant opposed the injunction application such and such, knowing making false misleading statement in some material the injunction order are granted based, but the grantor could not satisfy the court that based on which misleading statement the court granted this. So Lordship, then the essence of the order is court had a knowledge on that day that that gentleman is not.
Knowledge of your allegation, that's
allegation. Then court
says
court
could
says
not
that
satisfy the court the basis of
not. If I say that someone is alive or dead, the court can always ask. They are filing something on affidavit. Court can always hold it for a day and say that they bring the enlistment certificate from the KMC.
This certificate was annexed to your 39-4.
No, that time we were. Lordship, kindly see. Then I have informed.
Take all these points in the suit.
No, Lordship, kindly see. I informed the court. I could not produce the document on that date. Now Lordship is in appeal. In the appeal, Lordship is hearing me, and now Lordship is looking into that document.
To convert this into a mini trial, definitely.
No mini trial, Lordship. But only thing is, Lordship, can I be that? I put this question to myself.
We could have considered if you had not failed to take the opportunity to file a written objection. You have not filed any written objection. We cannot permit you to do what you could not do directly.
I understand.
Indirectly.
No, Lordship, but the technicality says that I am all at fault. Now I am
technicality. You did not file a written objection.
I did not file.
They are all open to be taken in this.
Now, Lordship, kindly see today. No, Lordship, kindly see today. Lordship is again hearing that ad interim order of injunction, means interim injunction. Lordship is today is having a. That time I made a statement, I could not bring a document, but by supplementary document, I am saying that now.
We cannot convert ourselves to the first forum. This was not
Please don't.
the trial.
Please don't. Please don't. But Lordship, kindly see.
And even if that 50% goes, the other 50% remains. At least they have something to show that they were paying rent to at least one of the.
Lordship, the very basis. So, Lordship, I will what I will then beseech your Lordship is based on my father document, Lordship.
Liable issue is there because they have produced, at least they were paying 50% of the rent. That
Lordship
is there. Occupation is there.
In this case, Lordship, if Lordship I'm forgetting the law, but I am saying that prima facie, I am saying that their tenancy based on the only 50%, someone will be protected. Instead of doing that, may I beseech your Lordship? Lordship can remand me back for 10 days. I will make it out.
No question of remand. You try it out in the suit itself. Fight out in the suit and
then Lordship, I have to bear this order till the end. Lordship, kindly see how.
You remand it, we have to reopen the chance to file a written objection, which you don't want to do. Why should?
Yes, I will.
No.
At least I will say these documents, Lordship, I will say that these two documents which
You had a chance, you did not file a written objection. Why
Lordship,
should you reopen that for
yes,
you?
someone tried. Someone said that if I say, maybe someone who has conducted the trial
No,
there.
Mr. Banerjee, no.
No, but Lordship, can I?
Not
Can,
at the
can I-
injunction.
can I-
This was the final. This was the
Lordship,
final.
I really shut my ears. Lordship, can I
Trial, you
really
take all
shut
this
my eyes and ears that someone is dead,
Oh.
his document has been used, but still I said that other 50%
Prove that in the
is
trial, Mr. Banerjee. Prove
Lordship,
that.
is it the trial? Lordship, someone is
No.
someone.
We take up the appeal itself for hearing along with the application in view of the
Cannot keep
conspectus.
the space with Lordship to say yes against no. But then Lordship,
In view of the conspectus of the hearing of the application being co-equal with the issues involved in the appeal itself. Full stop. Next para, heard learned counsel for the parties. Full stop. We find from the impugned order that by virtue of the same comma, the application of the defendant stroke appellant under Order 39 Rule 4 of the Code of Civil Procedure was rejected, and in the same breath, comma, the application for temporary injunction filed by the plaintiff stroke respondents was allowed. Full stop. It is pointed out by learned counsel for the respondents that a single appeal has been preferred. Full stop. If we construe the appeal to have been filed against the rejection of the application under Order 39 Rule 4 of the Code of Civil Procedure, comma, in any event, comma, the appeal would be futile ab initio, since even if the Order 39 Rule 4 application were to be allowed by setting aside such portion of the impugned order and the ad interim order vacated, comma, fact would remain that the temporary injunction application itself has been allowed, granting injunction till disposal of the suit, comma, thus rendering the relief in respect of the Order 39 Rule 4 application futile. Full stop. Next para. On the contrary, comma, if we if we construe the appeal to be one under the one against the allowing of the Order 39 Rules 1 and 2 application of the plaintiff's respondents, comma, in that event, comma, we have to take into consideration that no written objection was filed by the defendant stroke appellant to the temporary injunction application, and as such, comma, the trial court was entitled to proceed on the doctrine of non-traverse. Full stop. We do not find from the records anything to show that the application under Order 39 Rule 4 of the Code of Civil Procedure was treated or directed to be treated as the objection to the injunction application, comma, as is sometimes done. Full stop. Thus, comma, seen from such perspective as well, comma, no arguable case can be made out by virtue of the documents annexed with the supplementary affidavit filed by the appellant beyond the pleadings of the appellant in the trial court, comma, since the appellant chose not to file any written objection at all to the injunction application. Full stop. What cannot be achieved directly by the defendant stroke appellant cannot be indirectly permitted in an appeal, comma, since in the absence of any written objection to the injunction application, comma, we cannot permit new documents to be brought in by the appellant which were not even produced before the trial court. Full stop. Next para. Even taking the case of the appellant to its highest, comma, the appellant argues that one of the alleged co-landlords had met her demise in the year 2007, whereas rent receipts purportedly signed by her have been produced by the plaintiff's respondents in the trial court to substantiate alleged payment of 50% of the rent for the suit property. Full stop. Next para. We find from the ad interim order dated May 6, 2022, which was ultimately made absolute by the present impugned order, comma, that the learned trial judge categorically held that although the defendant's advocate had verbally stated that pro forma defendant number 4, Shanti Devi Bagri, had died
but he had not filed any written application or document to that effect. Full stop. Next para, in the event the appellant is permitted to file the purported death certificate or any document in support of the alleged death of the said Shanti Devi Bagri at this stage, comma, the same should be subject to appropriate scrutiny, comma, which scope is always there for the appellant in the trial of the suit itself. Full stop. Next para, as on the documents which were produced in the court, in the trial court, comma, we find that the plaintiff stroke respondents have made out a sufficient prima facie case to go for trial by producing rent receipts in Hindi vernacular allegedly issued by one of the by some of the co-landlords, comma, at least in respect of 50% rent of the suit property. Full stop. That apart, comma, the plaintiff's respondents have also produced documents to show that they are in occupation of the property, comma, by way of certificate of enlistment and other relevant documents, which were considered by the learned trial judge at the time of granting ad interim injunction as well as in the final hearing of the temporary injunction application. Full stop. Thus, comma, we find that the learned trial judge was justified in granting temporary injunction to protect the position of the plaintiff stroke respondents till the disposal of the suit, comma, since an arguable case has been made out by the appellant, by the respondents. Full stop. Next para, it is right law that in that while hearing an injunction application, comma, the court cannot convert such hearing to a mini trial of the suit itself. Full stop. In the event the documents sought to be furnished at this belated stage by the appellant are permitted to be taken on record, comma, it would be unfair since those were not before the learned trial judge at the juncture when the impugned order was passed, nor at the stage of passing of the ad interim order, and
Ad interim
unless
was ex parte.
ad interim
Was ex parte.
yes, and unless those documents are formally proved as evidence in the suit, comma, it would be inappropriate at the injunction stage to permit those to be produced for the first time in an appeal against an order whereby an application under Order 39 Rule 4 has been rejected and a temporary injunction application has been allowed. Full stop. Next para, in such view of the matter, comma, we do not find any infirmity in the impugned order. Full stop. Accordingly, FMA 848 of 2024 is dismissed on contest without any order as to costs. Full stop. Next para, Can 1 of 2024 is dismissed consequentially as well. Full stop. Next para, it is, comma, however, comma, made clear that the merits of the contentions of the parties in the suit have not been gone into by this court, and the learned trial judge would be at liberty to decide the suit by trial on evidence independently without being influenced in any manner by any of the observations made in our order as well as in the order impugned before this court or passed by the learned trial judge at the ad interim stage. Full stop. Next para, no arrest cost. Urgent certificate cost. Correct.
At least a expeditious here.
Which year suit?
Suit is correct, but then current suit, Lordship, but then
Which year?
22 current, Lordship, but still, if your Lordship kindly, since I will be suffering this order, if your Lordship kindly expedite that, then in that case, at least say that none of the parties will take any adjournment in the matter.
Can we say that?
Yes.
You may take adjournment. No.
I mean,
Oh, sorry. It a judgment form.
I'm repeating.
Next.
Item number 41.
41, my lord, I am appearing for the appellant.
I am for this number 2. One applicant.
My lord, I am praying for not this week, my lord.
Well, you are competent enough. Move the matter, Mr. Banerjee.
My lord, I am led by Mr. Onmanaj in the matter. He is engaged.
You are Suman Banerjee.
Yes, my lord.
So Suman Banerjee is sufficient. Yes, move the matter. One Banerjee will do. What is the application for?
My application.
Your application. What is the application?
He is
For appropriate order by recalling the order dated 11th August 2022.
Mr. Banerjee is in court. Mr. Banerjee.
Yes, he is engaged in court room number 36. I have been informed.
The application is for what?
For recalling of the order, my lord.
Recalling of the order.
Order was initially passed by their lordships, my lord.
Appeal is admitted without formulating one substantial question of.
Question
You
of
want a formulation of the?
Yes, ma'am. And according to my lord,
Lord.
the amendment of the specie, my lord.
That's what you say to this.
And
You didn't have a right of hearing then. At the formulation stage, you did not have a right of hearing because we go back to the date of the order for 2011 hearing.
Lord.
Subsequently, at the time of final hearing, let us see the civil procedure code.
judgment, my lord.
Before the judgment, let us just look. Yes, Order 42 Rule 2 mandates the court to formulate substantial question of law. And it may also say that this will be the only grounds on which it will be heard, or it may leave it to the appellant to urge any other ground in the appeal at the final hearing. Final hearing, it can be formulated, but it's mandatory at the stage of admission to formulate.
My lord, what happened, my lord? Actually, on the date when the order was passed, when the matter was taken up for hearing before their lordship, we sought for stay of the operation of the impugned judgment and decree, my lord. So, my lord, what happened? Their lordships felt it.
No, you are the appellant.
Yes, my lord, I am the appellant.
Oh, your appeal was admitted without formulating the substantial
My lord,
question.
we sought for stay of the.
Then you are the only person who will hear, not him.
Yes, my lord.
If you have to formulate substantial questions, you don't have a right of hearing. You have to hear him then.
Lord, this.
His appeal, you want a recall of that order, that the appeal admission should be recalled.
Yes, my lord, my lord.
Since question of law has not.
114 and facing to judgment.
Let Mr. Banerjee come. Whose order? Which bench? Then let's see the order.
My lord, the order is appearing.
Let Mr. Banerjee come. Yes. An adjournment is sought on behalf of the appellant. Accordingly, let the matter stand adjourned for the day. Chakravarti, wait for Mr. Banerjee. We have to be. This is crucial. It may be recalled also.
Today, my lord.
No, not today. Today you will be have to be.
Tomorrow.
Next week, not today means tomorrow it will appear in the list, but tomorrow is the appeal hearing day. Day after tomorrow is the single bench day. Monday. So it goes to Monday.
Fix it Monday, my lord.
Fix it Monday. Very good. তাহলে যেটা বললাম adjourn for the day না করে adjourn till 16 June 16 2022. You are assisting him.
No, I am for the number 2.
1 and 2. আচ্ছা. It's his application. Yes.
My lords, I appear for the respondent in the matter.
Yes.
My lords, we've been served with the papers. We would request a short accommodation to file our detailed reply on record, and the matter may accordingly be posted for hearing.
The appeal was admitted.
Please, my lords, the appeal has been admitted. Delay has been condoned.
No, my lords.
No, appeal was not admitted.
The appeals are admitted.
Ma'am, at the order 41 stage, you don't have a right of hearing. Unless we admit the appeal.
My lords.
This is against injunction.
Lordship, may I just say, I have also been called by them who's appearing.
No, this is against injunction, refusal or grant.
Maybe.
Grant.
It is against.
Refusal. No, then in any event, immediately after admitting, we have to hear them.
Lordship, I have been contacted by them from Pune. This is the clients are based in Pune.
You are for the respondent.
Lordship.
You are for the appellant.
Appellant. And the only thing is, Lordship, they are yet to send me all the papers. They've received it. I was seeking a week's time. I'll go through the papers and maybe able to in a position to assist my lords. I don't even know what the matter is about. I have already told
When
them
should
that
you keep it? Tell us.
Lordship keeps it next week. We'll come back.
Next week when?
Whenever, Lordship. Next week, Monday. I'm sure they'll give me.
Whenever you say whenever, when we fix a date, you say
Monday.
on that date, except on that date.
Lordship,
It happens in every matter. So give a date.
Lordship, anytime after Monday.
Any day after Monday.
Lordship,
So you are more
Wednesday is
specific.
Wednesday is fine.
No, Wednesday is difficult.
It's difficult for my lords.
Wednesday, no, not difficult. Wednesday, all right, yes. Wednesday we can keep. Wednesday we'll keep it very well. You have no difficulty. In any event, you would be paying for adjournment. So on the prayer of learned counsel for the parties, the matter is adjourned and shall next be listed on June 18, 2025 under the same heading. Please come back on that.
Lordship.
Obliged.
Thank you.
I picked the filter. সুরেন্দ্র রাজু বসে বসে যখন হাজার বার বলছি ছুটি করতে আর দুটো জাজমেন্ট থেকে 10টা জাজমেন্ট আছে আমরা করতে পারি ওরা একটা বিকল করে আবার তাহলে আবার ফিক্স করতে হবে অর্ডার করতে না ওরা আমরা শুনে কল করে শুনে নেব যদি ওই অর্ডারটা রিকল করে অ্যাডমিশন অর্ডার থেকে না সঙ্গে সঙ্গে আমরা বলবো যে আমরা অর্ডার করতে হবে না এটা শুনে নিচ্ছি বলে ওকে ফ্রেশ হিয়ারিং দেবো অর্ডার করতে হবে না তারপর যদি হয় তাহলে Mr. Banerjee, can anybody inform Mr. Oyon Banerjee? Does anybody have touch with Mr. Oyon Banerjee? If anybody is there who can contact Mr. Oyon Banerjee, just tell us whenever. Because in a matter in which Mr. Banerjee was there, time was granted 2 matters back. It's an application for recall of an order admitting their second appeal without formulating substantial question of law. So it will be indicating to Mr. Banerjee that if you recall that order, because Supreme Court is very clear on this, then immediately we'll hear it under order for 10 Rule 11 afresh. So that has to be just informed to him if you can. If anybody can, I mean, it's just a general thing. So Banerjee has to be informed. His matter will hear out the appeal under order for 10 Rule 11 if you recall them immediately. Thank you very much. Yes. Call, who is appearing in this? Konta call 43 who is appearing? কি প্রপার কোড ফি দেয়নি deficit code fee direction দিয়ে দিই deficit code fee we find from the office report that deficit code fees of rupees 6650 have not been deposited by the appellants full stop accordingly no accordingly na we also now it also transpires from our order dated May 13 2025 that the appellants had been directed to rectify the defect by depositing the deficit code fees before the next returnable date, that is June 2025. Full stop. However, till date there is nothing on record to show that deficit code fees have been paid. Full stop. Moreover, none appears for the appellant at the time of call. Full stop. Let the matter stand adjourned till June 16, 2025. Full stop. The appellants shall now let the matter stand adjourned till June 23, 2025. Full stop. The appellants shall deposit the deficit code fees within the said returnable date. Full stop. In default, appropriate orders will be passed on the returnable date. It is 23rd June, same heading.
I appeal for the petition.
Yes.
But you would recall this is, Lordship has heard this substantially. This is with respect to a disciplinary proceeding, and we wanted a stay of the disciplinary proceeding, where the defendant I am the employee of the defendant number 1 organization, and it was my contention number 1 that the HR manual under which the proceedings are continuing, that is beyond the without the authority of the executive council of the defendant number 1. So without the authority, the HR manual has been framed, and under that HR manual, we are show cause, etc. was proceeded. It's like, secondly, the defendant number 4, who was the disciplinary authority, that was the person, because when we write to the defendant number 4 that what is your qualification, how can you hear this, the defendant number 3 answers me saying that please do not say such things to the defendant number 4. So we said that there was also a collusion.
No, you have been terminated.
Lordship, now, my lord, what has happened? No, I'm not being terminated. At that point of time, when we filed, Lordship, we were not terminated. Lordship, the last occasion when Lordship heard, and it was assured.
Filed for what? So what
for
was the relief?
Stay of the disciplinary proceeding. Now, my lord, when the last time Lordship heard, and we, Lordship, I believe we had convinced that this person, and Lordship had felt from Lordships that a different person may be appointed and Lordship will appoint somebody before whom we can go. Lordship, in order to overreach this honorable court, the defendant number 4 was removed. Another person was appointed. We and dates fixed. We said that this appeal is pending.
Why overreach? That is in consonance with our expression of thought. I mean,
no, my lord, it was Lordship that either we agree or Lordship will appoint.
So instead of us, they appointed. They arrogated themselves to court. No difficulty in that.
No.
Nowadays, that happens every day.
That is the difficulty. That person,
Another person
proceeded,
has been appointed.
And
terminated.
and we said that this appeal is pending. He proceeded, and he has now I've been terminated. Now the vindictive action is to such an extent that not only I've been terminated, they have also said that they will also not give the gratuity. That is the level of vindictiveness on the part of the. Now, my lord, there are two issues. One is with respect to of the HR manual. So, my lord, kindly may I please.
But what sort of an order do you, interim order do you expect now, Mr. Ali? Then
The
you have
status quo ante, my lord.
Status quo ante.
Lordship kindly takes, because this happened during pendency of the suit. Lordship kindly takes page 80, the page 54. Page 54. This is the rules and regulations of the defendant number 1 organization. 1.1.e, Lordship, the Executive Council. This is, my lord, the Executive Council is composed of various members, my lord. They are the very senior officials of SAIL, Tata Steel, etc. Executive Council means Executive Council of the Association for the time being elected and appointed in the manner prescribed by these rules, which term shall include Executive Council members. Therefore, Lordship takes page 80, one of the functions of the Executive Council. 9.6.4, without prejudice to the mayor, please. One page 80.
Yes.
9.6.4.
Yes.
Without prejudice to the general powers conferred above, the Executive Council shall have powers. Now see,
print is very smudged, Mr. Ali. You should have checked that.
Is
The upper portion of the pages are very, I mean.
It is actually.
Anyway, let us continue. Yes.
Executive shall have powers to powers. Lordship then kindly comes to see, my lord.
Yes.
I hope it is legible. To make such bylaws, not being inconsistent with these rules for the time being, for the management of the association. This is the respondent number 1, as they shall think proper and from time to time to amend and cancel any bylaws for the time being in force, and to appoint, dismiss, and exercise full control regarding the working of the employees of the association. Now, my lord, the Executive Council has the power to make bylaws with respect to the services of the employees of the association, the defendant number 1. Well, till before the HR manual, which was introduced subsequently, well, the rules of sale was operative against us. The rules and regulations of sale. If any change is required to be made, that can only be done by the Executive Council only. In the present case, a HR manual has been circulated by the defendant number 3, saying that this is the HR manual from now on, and this. So I question the person that how this HR manual has, whether there has been any approval taken from the Executive Council. Under this new HR manual, the defendant number 3 is the judge, jury, and executioner. So, my lord, so this is that is the problem. When I ask him how they have got the authority.
What is the designation of defendant number 3?
Defendant number 3 is the Director General of defendant number 1.
Of?
Defendant number 1. And defendant number 2 is the President of the Executive Council.
So defendant number 2 had no role to play here?
No, my lord. Rather, Lordship, it also fell from Lordship that they let the defendant number 2, either him or anybody who he may nominate can be the disciplinary authority. But the question remains, one aspect is the disciplinary authority. The other aspect is with respect to whether the HR manual under which all these steps are taken, whether any approval has at all been taken by before formulating them.
HR manual has been annexed here.
Lordship. Page 98 is the HR manual. And at 97, Lordship will see the email by which the HR manual for the first time was circulated.
It is authored by whom? Who is this P.K. Mishra?
This is the P.K. Mishra is the Director General. I'm not the only employee who is facing this wrath. You have to be a yes man. Otherwise, disciplinary proceeding. That is the that also was.
Unless you are you are a yes man, you will be in no man's land.
Yes. Right now, I've been terminated now. Although this appeal was pending.
What is the relevant provision of this HR manual for termination and disciplinary?
So termination, there is no issue. There is no specific.
And disciplinary proceeding?
Disciplinary proceeding, they have.
As per this HR manual, the executive.
Page 14. Section 8, my lord, under the contents, page 99. Conduct, discipline, appeal rules, misconduct, suspension, substances along penalties.
No, any power has been given to the executive council under this?
No, nothing.
Who does it?
The Director General.
He himself.
In fact, he himself issued the show cause. He himself appointed the disciplinary authority. And then he terminates.
Who is your appointing authority? Appointing authority?
Of the appellant or Lordship, the Executive Council has appointed by taking interview.
Who has issued appointment letter?
Page 93 is my appointment letter. It must be the defendant number 1 has issued, but the Director General has issued the defendant number on behalf of defendant number 1. I'm working from 1999. No complaint. So, the long and short of the matter is that how the defendant number 3 has taken over, and till date there is no meeting.
Is there anything regarding the role of the Director General in the rules and regulations?
The new rules?
No, the old rules. New rules are not rules. Those are
HR manual. No, there was nothing. Executive Council was the all in all.
Is there any mention also of this Director General? Any role assigned to him? Not sure. ডিসমিস করতে পারে বলছে যে
and the show cause which was issued, the charges was I was talking to other employees.
যে শোকজ ইস্যু করছে সে ডিসিপ্লিনারি কমিটি করতে পারে না, সে করছে যদি শোকজ ইস্যু করে যদি একই লোকের আমি শোকজ ইস্যু করতে পারি। আমি একটু করতে না এখানে এক্সিকিউটিভ কাউন্সিলকে যে যে করছেন হ্যাঁ, সে কাউন্সিল অ্যাক্টিং এজ এ হোল না, কাউন্সিল এখানে বলা আছে যে কাউন্সিল shall include council shall include council members. কাজে মেম্বারও করতে পারে, মেম্বারও
2-3 more documents, Lordship. Page 214. The fact that the Executive Council was in the past deliberating on the issue of framing service rules, because the Lordship would recall the tail rules with respect to services of the employees were prevailing for us. Now the Executive Council was deliberating on the issue whether a new service rule is required or not. Lordship, at page 214, this is the note sheet of the Executive Council. This is the meeting of the Executive Council.
Director General signs it.
Yes, my lord, but this is the Executive Council's meeting minutes. Lordship, will see in the
Director General
15th,
is a member of the Executive Council.
Lordship, I believe.
Should be.
Remember.
Mr. Banerjee do you have any idea? Director General must be a member of the Executive Council also.
Elected members I've seen.
Should be, otherwise he could not have signed this.
I am the appointing authority.
That is always there.
Unless I become a
Cannot.
appointing authority, I cannot start the proceeding against him. What he is today saying that he is the appointing authority, he is forming the IO and he is putting the punishment. But under labor law, that actually has to be done. If I am the appointing authority and same designation, another man who is there, he cannot initiate proceedings against.
Yes, Mr. Ali.
Lordship, in the 15th the second paragraph, in the 15th Executive Council meeting on 26 July 2001 at Ishpat Bhavan such and such, Lordship, the INSTAG will align with personal manual in respect of personal and administrative rules as applicable in JPC. In this regard, it is mentioned that JPC follows sale rules in totality. Again, in 35th meeting of Executive Council of INSTAG held on 19 January 2009 at Hyatt Regency, Kolkata, point number 6.3, it was mentioned that regarding service rule of INSTAG, it was decided that there is no need to prepare new set of rules. Instead, sale rules should be followed. So, there are two things I want to establish from this. One, that sale rules are followed by, used to be followed by the defendant number one and for the employees of the defendant number one. And the Executive Council was deliberating on this issue. So, it is the jurisdiction of the Executive Council alone to frame the service rules. So, well, in the event they show that they have the Executive Council has framed the HR manual, Lordship, that is the end of the matter. With respect to the issue of validity of the HR manual.
So what about this in page 50, at page 57, 54?
Those are the rules and regulations of
Yes.
the association.
Executive Council
the definition says executive council shall include executive council members.
Members.
So
They are elected members.
why can't the director general as a member of the executive council do that?
Because it has to be done in a meeting, my lord. It cannot be done other than a meeting.
It says executive council means the executive council of the association for the time being elected and appointed in the manner which terms shall include executive council members.
Yes.
Read with
So the members shall make bylaw, not a member, not a sole member, my lord.
The executive council shall have powers, right? So according to you, this HR manual could not have been constituted as a bylaw.
Could not have been. And all these steps are taken. The HR manual was brought to keep control on the employees. Because this person, the actual, which is part of another suit, this person is a non-technical person, has no background in steels. We questioned his appointment. That is the reason all these things are. I'm removed. The others will keep shut. That is the entire strategy. If others keep questioning, they shall also be terminated.
But that is your perception. Some amount of control has to be there on the employees. Otherwise, no system can run.
I'm working from 1999. A 26-year-old employee living in fear of termination, just to say that.
But there was a disciplinary
have to fall
procedure
in
by the appointing authority itself, as mandated by the service laws also, basically.
Yes, if
general service law is there,
they would have done that. The
jurisprudence is that.
executive council alone is the body who could have proceeded with this, and they would have appointed the disciplinary
So
authority.
according to you, this DG could have issued the show cause notice, but the
no
could not have issued also.
No,
but that also for every
for everything, executive council is the person as per the sale rules.
All right.
And Lordship, only one thing: who are the members of the executive council? That is also
apparent that DG must be first of all. Secondly, DG signs this page 214 meeting minutes.
It is so illegible that it is difficult to find. But I only find that it should be elected. Whether there is any ex officio member that.
Where is that? Which page are you looking at?
That is the rules itself. Page clause 4 is a subscription for the members. Admission of members is clause 3 at page 59. No, it actually members of the association.
Clause 9.4.1 says after the beginning of each calendar year, the secretary and DG of the association shall issue a notice to members, calling upon
holding
them
election
to state
also.
within 14 days whether they wish to, can't read after that, stand for election. And if so, so it's a DG with the secretary who starts the process of election also.
And 9.4.2, all the members shall retire after every AG.
For 9.3.5 says the executive council shall appoint the association secretary and DG. It's the executive council who appoints the secretary and the director general.
So, well, this cannot be a member unless it's an ex officio, which I don't see, madam.
But the
1.1.e says all the members are elected.
3.5 also says page 75. The association secretary and director general shall be the administrative head of the institute's permanent staff and secretariat.
Yes,
They are
but
the
that is different
administrative
from the
head.
executive council.
No, if they're the administrative head,
Yes.
any specific procedure of termination is there in these rules?
In these rules, is nothing, but there is why it's shown. Well, the sale rules are to be followed, and they have not followed sale rules. That is
Sale
for
rules
certain.
do not provide for the termination then?
Definitely, they provide.
Where is that sale rules?
The sale rules are not have not annexed.
So those
But
have to
for the
place in-
sale rules, my lord, they have not followed. Admittedly, they have not followed sale rules. They have followed the HR manual.
No, the sale rules might import the DG to formulate a
But that is
HR manual. You
but
don't
that
know
is
that.
not their case. That is their case is that there is no sale rules have become a past.
All right.
The HR manual will now apply. So, my lord, my first point is the HR manual cannot be implemented because no approval from the executive council. The executive council ought to have come up with this HR manual. And secondly, lordship, the supplementary affidavit, lordship. Once they find that.
What is this?
Lordship, this is a supplementary affidavit which I have affirmed. Lordship, kindly takes page 20. In the meantime, what has happened? Page 20, the 29th May 2025. Lordship, my service has been terminated. Hence, the following order, page 21, the services of Ashim Kumar Samanto.
You did not give any written reply.
We gave a reply saying that the matter is pending before the Honorable High Court. And already one hearing has taken place. And if the video is all that is there, where an assurance was given that a meeting won't be called. And the meeting was called in a roundabout manner by changing the personnel. And page 22, Lordship will see now how vindictive a person can be, Mother. They are issuing a show cause for forfeiture of the gratuity as well. So for 26 years, Lordship, I have been serving. This is a show cause notice for forfeiture of gratuity under section 46 of the notice is being issued to you in reference to the disciplinary proceedings initiated against you with a memorandum of charges. The proceedings culminated in submission of inquiry report of the inquiry officer, Mr. Suranjan Kundu. This is the session retired, wherein the charge under Article 1 for committing misconduct, as described under Clause 8(9), was proved, they say, beyond doubt. After affording you adequate opportunity to respond, including service of the report on 21st May 2025 and again on 22nd May 2025, your reply dated 28th May was duly considered. It was found that contained no cogent grounds to displace the findings of the inquiry officer. Consequently, by order dated 29th May issued by the Director General and Disciplinary Authority, your services with Instag were terminated with immediate effect. It is noted that no appeal has been preferred by you against the said order. As per the HR manual, in view of the above, in light of section 4(6) of the payment gratuity, you are hereby called upon to show cause why the gratuity should not be wholly or partially forfeited on account of misconduct found established against you in course of your employment. Very extremely, I am facing the full wrath of the DG. Terminated, and also they say that the gratuity shall also be forfeited. But I am praying that the status quo ante should be restored, my lord. At least let them show that the HR manual, how they have, under which power they got that authority to adopt such HR manual.
Let us hear, Mr. Banerjee. Yes, yes, sir.
All right, can we see? We find three different suits. targeting the Director General that he is the most unfit person who has come into this. Why? He is an arts graduate. Plaintiff is a science graduate. He should have been there because he is working in the organization for a long time. So he filed 3 suits. One is 2104 of 2024, one is 1654 of 2024, and one is 196 of 2025, which is the present. Now, if your lordship, before I take your lordship,
What are the relief sought in these suits?
I'm coming one by one. Lordship, kindly turn to page 153, the injunction application. The present suit based on which this appeal has started. The personal occupying the designation of the respondent number 3, paragraph 8, namely Mr. Pradeep Mitra, has
Paragraph
got
8 is at which page?
155. The injunction of this starts at 152.
All right. 155. Yes.
And this suit is 2104. Lordship can see. Page 152, 2104. In 2104, he is writing.
There is a present suit.
No.
Other
suit. The aforesaid memorandum of charge is wrong, illegal, without jurisdiction. The personal occupying the designation of this, Pradeep Mitra, has got personal vendetta against. This should have been Pradeep Mishra, not Mitra. Mishra. Has got personal vendetta against the petitioner for the reasons which he is acting such and such. The same shall be evident in the year an advertisement was where chairman of the selection committee, respondent number 1, invited candidate for the apply of the post of director. Petitioner herein applied for the post of Director General, submitted all his necessary documents CV with his all terminal such and such, eligible criteria by FIPMAN in accordance with. Pursuant thereto, while waiting in the result of officer, the petitioner came to that one, Pradeep Kumar Mishra, being respondent number 3, assumed the post on such and such. So he contended for the same post. He was not given. So moment this Director General was completely a stranger to the organization. He was in sale as an executive director, and then this is a still authority. So he was brought in 2021. Prior to that, he cannot have any personal vendetta with this gentleman. What he said that we are extremely bad, it is not the story, because this gentleman was not in this organization any time before this. And rather, he was there for last 26 years. So he has got a grip and control of the organization much, much better than. So this respondent number 3 only came in the December 2021, precisely 2022. Now, Lordship, kindly turn to the next page. As per the rules regulation, the respondent number 1 in such and such memorandum, executive council shall appoint the institution secretary and on such and such. Then nobody was selected.
But he's filing a suit and making allegations against you.
Yes.
Are not grounds of disciplinary proceedings.
Then I will take your lordship that present.
So if you place too much stress on this, that itself shows that you had a vendetta. He may file a suit. He has a legal right to file a suit against you, challenging your qualifications.
Not saying
that cannot be a ground for disciplinary proceedings.
No. This is not that.
So then why are you placing this?
I am showing because he said that I had a vendetta against him. So I am showing no, I cannot have a vendetta. I came in 2022, but he filed one after another cases against me. That is what I wanted to give a reply to him.
Very well.
Now, Lordship, kindly turn to page 169. Lordship's order. When in the first matter, when they came up, when we issued a show cause notice to him that this is the target given to you.
In the present suit. Different suit.
No.
This came up from a different suit.
No. The cause, when we started first, suit is different, but the disciplinary proceedings initiated against him. We gave him a show cause notice. We set him a particular job to be done. Then he did not carry it out. He filed an suit against us. Then injunction was refused to him.
Suit in respect of challenging that show cause notice.
Show cause notice, and that proceedings cannot be drawn against him on this same ground. Then, Lordship, he came up in a interlocutory appeal before your Lordship. Then your lordship kindly see that was the order on December 2024, page 169. Lordship has got.
Got it.
Now this lordship will find in the second suit he filed challenge the authority and appointment of his respondent lordship, paragraph 5. Lordship, next page. There also he said that we are vindictive, so we did it. The said suit, the plaintiff failed to obtain any interim order of injunction. The vendetta was against the appellant by the respondent sergeant. Show cause notice was given to this. The show cause is the subject matter of the present third suit. Then lordship, the learned counsel for the appellant takes the court through the charge sheet. Lordship, then the charge sheet was there. The very act referred to the major penalty by harassment such and such, minor penalty such and such. He is thus submitted that unless a limited protection is given, then by way of pending, the learned counsel appearing for the restaurant controverted para 13. Next page. The very challenge made in the suit from which the present appeal emanates, it's contended that taking the court through the reply of the appellant to the impugned show cause notice that not a single specific allegation levies in the show cause has been made specifically in the said reply. So, lordship, in those round of litigation, I have taken your lordship that whenever we allege, you kindly say that what you are asking me, this is inhuman, I cannot do it. Or you say, no, I could not do it because of your 1, 2, 3 fault. So he neither take that, he comes on a technical ground and then he puts. That was pointed that the allegation in the purported reply to the show cause are all petition of the allegation made such and such. Then lordship, after hearing the present show cause notice such on subsequent cause of action arises out of this, then prima facie, then lordship is a very longish order. I am not going. Then para 23, in our opinion, para 23, page 175, in our opinion, it would be premature to admit the appeal, interfere with the learned single judge order, refusing interim order. At this stage, we make it amply clear that we do not enter such and such. So, lordship, this was the first round of this litigation. Now, lordship, kindly turn to present injunction arises out of a plaint. Plaint 196. If your lordship kindly takes up 196, sorry, they have not annexed the plaint. They have annexed the injunction, which is almost verbatim the same. So, lordship, kindly see injunction of page at
94.
194. Yes, lordship.
Yes. So page 196, same things are repeated.
Yes, yes. Now, page 194, he repeated the entire
Same things means same thing as in the other suit.
Lordship. He takes the same thing.
Yes.
Then, lordship, again, paragraph 8, verbatim paragraph 8. Then same verbatim paragraph 8.
Yes.
Then despite this, now lordship, kindly turn to page G. So, page 200, lordship. I said that he has been constrained to file another suit. Now, lordship, kindly turn to page 202. Lordship has got it. And now, lordship, kindly come to page 203, para 15.
Yes.
Lordship. So, lordship, the show cause notice he challenged. 203, lordship, at the bottom. He challenged those. He did not get injunction, so it has been proceeded with. Then, lordship, para 205. So, lordship, 205. Lordship, then he specifically said a UPSC cadre was this. Since the cadre is much below the rank of his because he is a GM of a society and UPSC cadre, being a cadre but much below of his intellect, he will not appear before him. And if he gives any explanation, it will be no. So then he humiliated that particular inquiry officer. He refused. He rescued himself. Then lordship, a retired district judge, district and session judge was appointed. He conducted. He gone there, but he did not make any, did not participate. And lordship, then he is coming back and saying that since assurance was there, he said, that is what he said, that he is not supposed to be done. The matter was not taken up, so he cannot do this. Lordship, now kindly turn to page para 23. This is how the manual has come into picture. 23. Pursuant thereto, the petitioner such and such on his jurisdiction, authority, qualification, relationship, such and such. It is pertinent to mention that it is absolutely necessary petitioner to seek such disclosure only to ensure. So he sought everything that UPSC cadre given everything. It is further pertinent to note that the HR manual does not disclose any criteria for appointment of inquiry officer compelling the prisoner to seek. So that means that HR manual, which he is today challenging, said that it cannot be. He said HR manual did not authorize him to do. So he banged upon HR manual to take his protection and shelter while he was moving this injunction application. Because Lordship, HR manual was circulated to him in 2022. Under that, he took the all advantage of that. Salary he has drawn under that. He has taken leave under that. All things have been done under it. Now, Lordship, kindly see, it is pertinent to mention the inquiry failed and or neglected to reply. So, reply was not given. Now, para 26. Para 25 and 26. On 16 January, the petitioner issued another letter to the Inquiry Commission seeking postponement and the adjournment of the preliminary meeting against such and such. The inquiry officer failed and neglect. However, the preliminary meeting was conducted by the inquiry officer on such and such date. On 27, on 18 January 2025, petitioner issued an electronic mail such and such. It is pertinent to note that the inquiry officer failed to respond. So whatever the things he wanted has not been responded. Now, Lordship, kindly see para 34. The tenor, I am trying to show the tenor of the suit, para 34 of the injunction itself. The defendant number 4 is not eligible to act as an inquiry officer for the following reasons. Then he said that particular gentleman is not entitled because of those reasons. That is what his case was. Now, Lordship, kindly see para 35. Para 35 is the prayer of the plaintiff. He has set out the prayer of the plaintiff. Lordship, kindly see, he has not taken a single challenge thrown to the HR man. Lordship, kindly see. Prayer A, the declaration that is not eligible to act as an inquiry officer with the decision pursuant to later this. The injunction from giving any effect and not further holding meeting such and such. Permanent injunction pursuant to such and such with the disciplinary proceeding with the appointment letter such and such in any manner whatsoever. So the particular suit goes with that respondent number 4 itself.
He sought an injunction
Lordship, can you see?
from giving an effect or further effect or action.
No, Lordship. May I read it?
In furtherance to the HR.
Injunction, defendant from giving effect on such and pursuant to such and such issued on this in connection with the disciplinary proceedings.
No, please read the such and such.
I am reading the entire. Slowly, I'm
such and such as it is.
No,
not as such as such.
Permanent injunction.
Read C as a whole.
Injunction restrain the defendant from giving effect, any effect, and or further effect, any effect or further effect, and or acting pursuant to and or in furtherance of HR manual issued on. So it is the qualification adjective given to HR manual in connection with the disciplinary proceedings pursuant to his letter date this. So the emphasis is on the letter. Injunction is on the 1st January 2025 letter, which is issued pursuant to an HR manual. Which HR manual date is this? So the injunction goes to 1st January.
Per se, this is not a challenge to the HR manual. In furtherance of the HR manual, you cannot give effect to this notice.
Yeah. So in fact, he is banking on the HR manual. So he has banked upon the HR manual and he has done so. So all these points.
No, please come to para 33 at page 209.
I'm coming, sir. I'm coming.
33
the petitioner has recently come to know that HR manual, which has been relied upon, issued to the said HR manual, all notices, including so-called notice this fame against the petitioner dated the appointment issued by the defendant number 3 in favor of such and such has not been adopted by the council of this. Thus, HR manual cannot be relied upon. So what he is saying that if something has gone on a beyond the scope of something, that cannot be relied upon. But he has to say that it is a nullity, the declaration has to be prayed for. And it is not his first suit. This is not his first time this is the third suit. He is the third attempt. First he faced the major penalty. That major penalty order has not been, minor penalty, I'm sorry. First he faced the minor penalty. Then also he chose not to rectify himself.
He never challenged the HR manual.
In all of these suits, Lordship, he has not challenged. Now today when he has been put to this, Lordship, he had got an opportunity. He could have gone to the investigating officer, inquiry officer. He could have given his all detail that what is the charge against him. We have given no charge that you have.
Sir Banerjee, did he take the point of lack of jurisdiction under the HR manual before the inquiry committee?
No, that also he has not done. That's what I'm saying.
Never taken this point apart from this suit or
prior IO was challenged on his qualification and intellectual.
Yes, that is true. And also that he was appointed by the DG himself on that ground. And his qualification, yes.
That is.
But the HR manual, that it is not. This point was not taken before the inquiry.
No, he has never participated there. He has gone there, given them letter and said, no, you can't do anything. I mean,
in the letters also, he did not take this HR manual not being applicable.
Lordship will not find in the four corner of this. So Lordship, every time he has threatened us that I have a high court, 4 matters are there, I will take away your chip. So Lordship, what he has been done, these are the small organization under different ministry and this.
Small. This is a small organization.
Yes, Lordship. Very small. It is
directly under the
society. Under society.
Directly under the ministry.
No.
So what is the authority of formation of this?
Lordship, for the steel development.
Yes.
A society is being formed.
By whom?
Society is formed by Mittals, Tatars, and company under government of
that society. I mean that steel development fund that we dealt with the matter regarding that.
How much production we should do? What is our country?
That's
capacity?
Not a small organization. It has charge of the entire steel development funds.
No, that is under ministry.
Yes.
This is not under ministry.
This is found by these individuals, operators.
Yes. But one of that company, major steel company, is safe.
Maybe, but still it's in the capacity of a steel.
Small, what they are doing is, many things government directly cannot do. Government cannot directly go to another country and say, you purchase my steel. A government organization cannot do. I'm sorry.
No, what it cannot do, it cannot do.
So then what we have is to promote the steel to the third world country and all, they have a small organizations. They are free. They can go and say, you purchase steel. I am suggesting SAIL steel is best. Salem steel is best. Mittal steel is best. So this gentleman have got you have to make member of all foreign bodies here, earn some profit. 20-25 people are working here, and they try to. Why this is strategic position? Because the developing country are on the eastern part of my country, like Bangladesh, Ceylon, Burma, these places. So they go there and then say, you take steel from us. Otherwise, this would have been done by the Russia earlier.
Anyway, that is immaterial.
So Lordship, today in this matter, he has been charged that you work. You are a GM, you have a qualification, please work. Then Lordship, he kept on fighting with the organization. And Lordship, I have shown that prior to 2022, I cannot have any miss.
Sir Banerjee, what is your answer to his query, his challenge, that the sale rules would prevail? That those rules and regulations he placed under which the Executive Council has the power to dismiss and...
Lordship, this is a society under 1961 Societies Act. Sale rules cannot be adopted by an individual. That is the Government of India company under 627 Old Act. It's a government company.
But what about this resolution by the
Now,
executive
Lord,
council?
I tell you, when this my own manual has not been formed, till the time my own HR manual was not formed, I have to be guided by something. So instead of taking the manual from Mittals or from the Tatas, I thought it is safer to the government company rules, which will be more modern. So then I am a society. I filed my return before the society. So in that case, Lordship, I have adopted someone's rule for a time being. Then my HR manual came in 2022. It came. Lordship, so his salary, sleep, pay slip, allowance, everything under HR manual. He should have woke up from the slumber and should have filed in 2022. When only I questioned him about his performance in the work, then he remembered that I should not be the DG. Then he remembered that sale HR manual should be used. Then he remembered that this proceedings is wrong. Then he said a UPSC cadre is much inferior to him. Then now, luckily,
Is the society registered under the society?
1961. So, Lordship, I have an experience that some 1 or 2 employees, only 3 employees, someone has filed a writ against the society and said that cell rules applicable, so it's a government. Then I argued that matter before Justice Kapoor. It is a reported judgment now. Even before Delhi High Court also this issue was there. Then I said there is no pervasive control of the government on this. Government is only encouraging a society to grow for R&D and research and marketing. So then all those writs are dismissed and they have preferred an appeal before the division bench, which they are in courtroom number 30, released yesterday. Released and then it will be released. So Lordship, today as of, if I stand on that, it's a society under society. So Lordship, this is from his pleading that he was contender for something and not. Lordship, how do I know that someone was there for 26 years, he is contending this. This gentleman retired from sale, he said that I can do this management job, I can do this, so he has come. So Lordship, now he has to say that everyone is inferior. This man is pricking him. UPSC cadre is unable to understand him. Now the judicial officer, that day I said, my lord, then forget it. I will not give. If he has got anything, then I will appoint a judicial officer. That day I said before your lordship, I will approach any retired judges of this court.
That has been done.
So that has been done. I have appointed a judicial officer. Lordship, can you see the name? Can you see the repute? Then he could have gone to the judicial officer. He could have taken these all points before him. He chose not to go there. He disobeyed him. He allowed him to pass ex parte order. That inquiry officer gave him 3 times chances that come and tell me what your grievances. He did not go there. Instead, he filed an application here and then a supplementary here. And then he is saying, now I have to status quo ante. He allowed that proceedings to happen all along. Now, Lordship, today, kindly see his supplementary evidence. So, Lordship, I have shown the tenor of the suit of 196 that do not say that HR manual will not be there. So, the suit itself was a more personified suit against that UPSC cadre whom was appointed. So, Lordship, now he has not succeeded in the suit of 2104 where he challenged the show cause. Where the Lordship has passed this order, it should have been gone back. He should have heard that injunction application, temporary injunction application. It would have been stayed, then he would have not faced this. He has challenged the issuance of the show cause against him itself. So he got the ample chance from that date till this date to go back to his suit, the other suit where he challenged this point which I have shown to your Lordship, the other suit. So he chose not to do that. He should have put a petition and get that matter heard. So he chose not to do that. He has 2 other suits in his hand. He did not do that. When he was appointed and put to notice that new inquiry officer is coming, he should have filed another application in the court below and say no. That also he has not done. Now, Lordship, kindly see the injunction application which they have filed, page 13. The present injunction application, Lordship. He has just filed it, Lordship. Can 2. Can 2.
Supplementary affidavit?
No, can 2. First I will see can 2 and then I will take your Lordship to supplementary.
Yes, can 2.
Lordship has seen can 2?
Yes.
Now, Lordship has seen can 2. Kindly see when it was filed. 17th of May. Lordship has got it?
19th May it was filed. Affirmed to evidence.
Firm date is
May, yes.
Now, Lordship, kindly see when this inquiry officer resignation was there. Kindly come to page 23.
One month before that.
Now, Lordship, kindly see first notice is received. 17th April, Lordship. Page 24. After appointment, the first notice he received on 17th April. Now, Lordship, after 17th April, he writes to page 26 to my inquiry officer. Now, kindly see the letter. Please refer to your notice dated such and such per to hold the meeting in connection with this. Being allowed since inception of this. So he says that 1/9/2022 was the date.
But he has challenged the operation of the
I'm coming, Lordship. However, the rules and such, the management is only authorized to approve a new rule. So can this be a scope of the inquiry officer, Lordship? Para 2. HR manual is not been approved by the management. Para 2, para 3. Then, Lordship, para 4 on this. In addition, I would like to the appointment of PK Mishra as this generally is illegal. 2 court cases such and such is pending. You might have noted that we is a complainant, controlling authority. So the jury, judge, execution. So his own cause, such and such. I am of the view. I am not next page, my lord, to resolve the above.
Will treat to be this to be the hearing of the appeal itself, along with the can. We'll continue.
Yes.
We'll mark it as if Mr. Banerjee agrees.
Yes, that I do it.
Because virtually the appeal is being heard.
Yes.
For all practical purposes, comma, the
But
issues
we'll keep it
involved in
tomorrow.
the application, it will remain in the list tomorrow. Issues involved in the appeal, issues involved in the applications are directly involved in the hearing of the appeal as well. So accordingly, we treat the present hearing to be the hearing of the appeal itself along with the connected applications. The matter is heard in part and shall be taken up for further hearing tomorrow.
I'm deep.
Part heard, so tomorrow is part heard. Appeal heading is the part heard appeal heading. Bracket can go. Thank you.
I'm great.